urgency.
But I am a blood bank, my lord. Suddenly, on 31st of July, the government has issued an unreasoned order saying I cannot conduct blood camps, my lord. If I am not in a position to conduct blood camps, my lord, I will not be able to function. I cater to more than 5 hospitals all over West Bengal and all over the state, my lord. My collections is huge in number. I am the highest blood donor, my lord. There is no allegation against me of any defalcation, any dereliction of any guidelines, any rules. I have all audited accounts, my lord, as well as the audited sheets with regard to the blood collection and blood donation.
So what you have prayed here?
My lord, I am praying, my lord, this be stayed, my lord, because this is the Independence Day month, my lord, where the blood collection is the highest. And suddenly an unreasoned order, my lord, will see once the order.
So if the authorities found your blood collection is degraded, whatever it
Nothing has been found.
Why-
There is no inspection, no
the court
show
should
cause. My lord,
why
there
the
is
court
no
should
show
interfere
cause,
all
no
these things?
inspection, nothing. My lord, they have just given a blanket order saying 10 people are banned. I am one of them. Why I am banned, I do not know. No show cause given to me. No opportunity of hearing afforded, my lord. It is an absolute dereliction, my lord, on the part of the government, my lord. My lord, will kindly grant us leave to move it urgently.
Leave granted, fix on Friday within 20 minutes.
I'm at last stage of renal.
What is the urgency?
I'm last stage of renal transplantation. Hearing taken place. They have said no, they will not grant any permission. So far, the verification committee is concerned.
Okay, that is there are several matters with regard to ART, no problem.
But you know, kindly, I'm last stage of renal transplantation.
Yes, there are so many matters, sir. So it is not so urgency. Let you file it when the matter come, it will taken. It is not your see, it is the main case. Thousands of cases pending here. Every day the advocates are mentioning with regard to the authorization committee rejected, then the court has to.
Authorization have granted the permission. There is a domicile certificate issued by the submission officer. Hearing taken place on 7th of July 2026. Nothing has been indicated to me whether they will allow, they will reject. They say verbally they will say.
The authorization committee has allowed. Then what remains further?
They have. That is the issue.
So you are telling that the authorization committee allowed.
See that is a domicile certificate. Subdivision officer issued.
Whether authorization committee examine.
Passed any order.
Whether the authorization committee examine order passed, then where is the cause of action?
Kindly, may I file and give their hand?
No, you file it, then we'll come. No mentioning on.
Urgent motion start from 13th August.
What?
NEET UG counseling start from 13th August. The petitioners name deleted. For that reason, SDO refused to.
Deleted which year?
This 2026,
2022.
Yes, already the petition is already. It is a long break.
So you not come on Saturday.
It is mentioned.
Why not come on Saturday? Saturday you not mention what all matter was listed. All matter has listed what. Sorry. Not allow any mentioning except unlisted. Next 2 days with regard to evidence you come. As per your choice, you cannot come every day. You come.
Student
I'm praying the granted gift to my lord.
What?
Regarding the Sabuni Mala is going to be held on 8th August. To the government land.
Where the Sabuni Mala?
The 8th Mala, the subdivision of the Tomli. They have not given any permission to the hold the Sabuni Mala.
Who will give the permission?
That is National Highway Authority, the executive engineer, National Highway Authority. So, they did not permit the last
So that I already rejected your sub.
This is rejected. They have been now to come up with the vendors list, but this is the annexing by disclosing that the vendors are coming. They have been the gate has been all shifted. Which has been by your lordship rejected this application last week. Regarding the date of the application after 31st July to 14th August. Thereafter, date has been held. Thereafter, they have been changed. The 8th they have been going to held. So he has seeking lead from your lordship to hold the
For what is the what prayer you made here before?
I prayed.
When you made a representation to the authority?
Authority, my lord, I made a representation on. This is my lord the last week, 2nd August of 2026.
2nd August. Today we are on
Today
4th
we are
August. So give some breathing time to the authority. Number one. Correction. What is the correction? What is the correction? Huh?
The correction of name.
What name?
কোনটা দিয়েছেন?
What name?
যে আমার তো হাতে লেখা যেটা।
Item number one.
No, no. For mention
Lordship, extension of interim order, Lordship.
Item number one.
Lordship.
Yes, why it is mentioned?
Name correction. Petitioner's advocate's name is not there. He has written it with pencil. হ্যাঁ তো হবে ওটা কারেকশন চলে আসবে আজকে না এখানে আইটেম ডেকে দিয়েছি
The matter is research to be mentioned on the prayer made by the counsel for the petitioner. The counsel for the petitioner submit that in the order dated the 31st of July 2023, the name of the advocate for the petitioner is wrongly recorded as Asmita Mitra was appearing in the matter.
Your Lordship, some other advocate's name has gone in.
No, the Asmita Mitra is appearing.
No. আরে পরিষ্কার বলো না হ্যাঁ মা না
চলো
Lordship, this is an extension of interim order, Lordship, and interim order is expired on 5th of August, Lordship.
Item number,
My Lord, kindly accept
My
this
Lord, item
donation,
number-
Lordship. Extension, Lordship.
my lord, item number.
matters are pending, my lord. Yes, sir, matter, my lord.
Yes, so is item number two.
My lord, my lord, we want to withdraw with the liberty to file a fresh, my lord, because there is certain technical defects, my lord.
Learned from the matter is research to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner prays for withdrawal of the present application due to some technical defects which cannot be cured by way of amendment, and accordingly prays for withdrawal with the liberty to file a press. In view of the submission made by the counsel for the petition, WPA 19446 of 2026 is dismissed as withdrawn with the liberty to file a press on the same purpose. Yes. Who is for the petitioner?
Petitioner, I'm being different with petitioner Thakkar.
Hmm.
He's just on his legs.
Huh?
He's just on his legs.
Let it be remain in the legs in the September. Yes, why it is mentioned?
My lord, may I am appearing virtually, kindly permit me, my lord. My lord, this is for restoration of an order, my lord, passed by your lordship. My lord, kindly take up the petition, my lord. I'll quickly indicate why this is filed. Your lordship will kindly take up page 11 of the petition. But I'm being led by Mr. Thakkar, my lord. May he take over, my lord.
Yes.
No, this was an application for extension of an order made by Lordship, my lord. On the returnable date, since we did not have an application in place, my lord was pleased to hold it. There is no.
Yes, Mr. Thakkar, you all persons are appearing with the group of the advocates. I am finding in your cost title 7, 8 advocates are appearing. None of the advocates are getting time to mention the matter for extension of time. And after the extension will be not 1 day, 2 days. After 4 days, you're telling that the interim order is to be extended.
I apologize.
Sir, the court can appreciate that you are a single person, you're dealing with the once the court has passed an order, I am finding 7 or 8 advocates for the petitioner. But for extension, I am not. This court is allowing all the extension.
Yes.
So why the juniors court appearing?
Even at the time of rising of the lordship,
I am allowing.
at all times the lordship.
Juniors is not serious to practice in the court. So why you are keeping all the junior with you?
I tender apology, Lord. I have just been inducted. I tender apology on behalf of my.
Every day I have to say the juniors, let place the case before this court. If this court find that you are facing difficulty, I will allow you time, but only asking the time.
This is
Before this court, this much of the bunch of the mentioning matters. Matters listed before the in the list. My senior is busy in court number 38. My senior is busy in court number 4. then the total till evening, the court is sitting idle. Only for adjourning the matter.
List collapses, my lord, it becomes very difficult.
So since from today I am not allowing any mentioning unless and until my any urgency.
My lord, this matter,
Urgency I will not, because I have seen the act of the bar.
my lord, for one or two mistakes, but kindly note.
Mistake, Mr. Thakkar, Mr. Thakkar, every day.
But I think we will, I will form this association, I will be secretary of the bar leveling association, and I will take it upon myself to take responsibility to inform the all the three who present when the matter is called. My lord, otherwise,
I am mentioning, I am fixing the date, taking into consideration of urgency number 1, number 2, number 5, but nobody is appearing. Yes, who is?
The respondent number 1, the respondent number 1, my lord, has filed his affidavit. I will file it within tomorrow. Next month, I think tomorrow, I will file it. The respondent has not filed his affidavit yet. So then it can be taken up.
Who is the added? You are added.
It's a direct legal matter. Challenges are formed but under the my lord, I think the added respondent has got several applications under IPC before National Company Law. The matter is at the final stage of hearing concluded, it's on the verge of reserve for order. At that stage, the petitioner, without taking a party, comes before this court, files a petition, challenges the form B, stating that the deemed to be authentication one of the legal grounds, and he obtains an interim. Now, after he obtains an interim order, he goes back to National Company Law Calcutta and says, let's see, this form B has been stayed by the Honorable High Court, so you do not proceed with this matter. And then he comes back and files an application and says that please add the financial creditor apart. First, he obtains an interim order without taking a part. Then the interim order clearly clarifies by my lord that they cannot take the benefit of it in NC. So parts say national can proceed.
Yes.
But however, they misrepresent this order and say that the High Court has stayed your so you do not proceed. And then they comes try and be as a party and try to make this order applicable on. This is the submission I made on the last occasion when my lord it has noted this submission, but however, if they have not prayed for extension of the interim order within time, so my lord has simplicity vacated. But my lord, I say today it is not a simplicity extension. They have to prove before my lord that they are entitled for this interim order, and they have to show a prima facie case that they are entitled for this interim order. So Mr. Thakkar cannot just simplicity pray that we have obtained an order, kindly grant an extension. Because kindly see now the application that they have filed can do. This is the.
But I'm willing to argue the merits of merit matter and from merits. The children are not in the habit of shying away from arguing from one side.
File the affidavit.
No, my lord, first and foremost,
Directions are given to file affidavits.
on 28th of July, I have been added as a party. So I have my time to file. But be that as it may, I can go on arguing, we can file affidavit. But we shouldn't stall my NCLT proceeding, wherein my lord formed is an
When the proceeding is when the
7th
next.
of August. 7th. That is the reason they are making so much of there is so much of urgency. 7th of August it is. And kindly see what the NCLT orders has to say.
Yes, but kindly see the NCLT orders.
Yes, right.
Kindly see the NCLT orders once. Whether we have made any representations to state proceedings, all these submissions have been made. Kindly see the NCLT orders.
Kindly see the Can 2, page 11 is the 14th July interim order. And thereafter, 4th July interim order admitted, kindly my lord comes page 11, the last paragraph, 6. In the meantime, the respondents are restrained from taking any benefit of Form D, wherein it is mentioned that the authentication completed on February 16, 2023 till the next date of hearing. Admittedly, as of that date, I am not a party. Now, what they did, my lord, 14 July, now my lord kindly comes to page number 14.
उसको बोलने दो जो बोलना है उसको.
the same similar set of councils they appears, and this is the representation they make on 23rd of July. In view of the fact that the writ petition preferred by the corporate debtor challenging Form D certificate issued by NESL and the same is pending before Honorable High Court and some interim order has been passed, we deem it appropriate to adjourn the matter for a period of 1 week. In view of the writ petition before the High Court, we list the matter on 7th of August. So because of that interim order, my Section 7 application has got stalled. And that interim order was not on me also.
Yes.
But definitely, my lord, since Honorable High Court has passed an order, National Company Law Tribunal cannot proceed unless and until there is a clarity.
Okay, how soon you file the affidavit?
My lord, I can file the affidavit within a week or so, but my lord, kindly clarify this thing. That it is because now my lord kindly take the ground that they have obtained.
What is the 7 the application under Section 7 you are filing before the time?
My lord, that is the under the IBC. Kindly my lord, take the insolvency and bankruptcy code, and I will show that it is not mandatory for NCLT to rely upon form.
That's why whether that in your application you are relying upon the Form D and you're taking the benefit of the Form D or not.
That is all. Court can ignore Form D and on the other because what Form D? My lord, kindly takes the IBC once and allow me to place this section.
It's separate.
Yes.
Section 7.
Yes.
The financial creditor, along with the application for record of default recorded in the information utility or such other record of or evidence of default as may be specified. So this is an information utility which has to be filed. Now my lord kindly comes to explanation 1. My lord has found that after subsection 5 explanation, for the purpose of this subsection, it is hereby clarified that where the requirement under clause 8 has been complied with, no other ground shall be considered to reject an application filed under section 7.
Yes.
So, if I file a form, then straight away court will admit it.
Correct.
Now, if they are disputing form D, what used to happen when form D was not there? Then the court used to adjudicate the claim on the basis of the loan documents, on the basis of the statement of accounts, on the basis of the other loan recall notice. So it is not mandatory for National Company Law Tribunal to only look into form. If they are disputing, very well, we will argue. But that has got nothing to do with my hearing of my Section 7 application that can move independently without it. Because the first order that my lord has passed, that they cannot take the benefit, may I now for the first order of 2nd of July, my lord has passed the order that respondents are refrained from taking the benefit of form D. Very well. We are not taking the benefit, but my lord kindly clarify that NCLT can proceed independently without taking the benefit of the form D. Let them argue their form D. I will also find my application. Will argue.
Yes, Mr. Tucker.
My lord, what with the greatest of respect, what the NCLT can do or cannot do is not the subject matter of this proceeding, and your lordships do not interfere with proceedings of the NCLT. What your lordships have always said is that the respondent not to rely on Form D. If without relying on Form D and is happy that he can do his matter without relying on Form D, no clarification is required. That is for the NCLT to decide whether Form D is relevant or not. You cannot have an order saying NCLT to proceed and then goes and tells the NCLT, now I am not relying on Form D, but the High Court has said, please proceed. That's what he's trying to do. I am only seeking this much, he cannot rely on Form D. He can do whatever he wants to do. If he can prove his case independent of Form D, then I don't understand what this vociferous opposition is. That is
Yes.
Just I have got my lord information that the matter has been listed. Matter has been listed. My monthly list.
It's on
10th August.
Anyhow, my lord kindly consider the grievance as their grievance. Then they have come before this honorable High Court. It is the my lord, there is a regulation. Grievance cell is there, my lord. The kindly consider it up to your lordship.
Okay.
I have already
the
submitted
petition,
the
the petitioner has filed the present application being CAN 2 of 2026, praying for reimposition of the interim order granted by this court on 28th of July 2026. Good. And counsel for the petitioner submitted by an order dated 28th of July 2026. 14 July. Reimposition. Counsel for the petition submitted by an order dated 14 July 2026. This court has restrained the respondents from taking any benefit of Form D, wherein it is mentioned that the authentication completed on 16th of February 2022. The said order was till the next date of hearing, and the next date for hearing was fixed on 23rd of July 2026. On 23rd of July 2026, so the matter was listed, but the matter could not reach, and the petitioners have also not prayed for extension of interim. Accordingly, interim order was not extended. The matter was taken as per the submission. The matter was listed on 28th of July 2026 under the heading to be mentioned. Under the heading to be mentioned. On the said date, Kamal under counsel for the petition placed for extension of the interim order dated 14th July 2026. July 2026, but this could find that the interim order was till 23rd of August, 23rd of July 2026, and thereafter the petition made an prayer, not review the prayer for extension of interim order, and on 28th of August 28th of July 2026, there was no interim order. This court has not extended the interim. Now the petition has come with an application for reimposition of the interim. Learned counsel appearing for the added respondent submits that initially on 14th of July 2026, the petitioners have obtained interim order in the absence of the private added respondent, as the added respondent was not made party to the writ application. And on the basis of the said order, the petitioners are taking adjournment before the tribunal. He submits that due to he submits that if this court extend the interim order by clarifying that the tribunal can proceed with the matter without taking into consideration of the Form D, he has no objection for extension of the interim order. In view of the above, this court find that initially this court find the prima facie case in favor of the petitioner, the interim order was granted, but subsequently none has reviewed, no one has made any prayer for review of the interim order, the interim order was not extended. And when the petitioner reviewed the prayer for interim order, by that day the interim order was already expired. Now the petition has come with the present application. It is a specific stand of the added respondent that the tribunal, he will proceed with the matter without taking the benefit of the Form D. In view of the above, the interim order dated 14th July 2026 is reimposed by restraining the respondents from taking any benefit of Form D, and the tribunal is and it is made clear that this court has passed the interim order only with regard for taking any benefit by any of the parties with regard to the Form D, which is the subject matter of present application.
Deeply objection.
Can number 2 of 2020 is disposed of. Let the matter appear on 10th August.
If he finishes his opposition.
No, the matter is already
clarified.
I already clarified.
But if he files his opposition, we can have the
You will
matter
file
finally.
appeal, then I will extend the time.
It's from 10th of August, by that time I'll file.
No, I have to file a reply. Please.
Okay, let it come on 10th. If they will file, if they will file, if they not want to file, then I will fix the hearing.
Well,
Okay, let the matter appear on 10th. Extended बोले ना, reimposed till 10th of August. Till 10th of August. Let the matter appear on 10th of August.
grateful. Deeply obliged, ma'am. I apologize, ma'am. No matter question at
Urgent motion. Yes, next.
Your Lordship, it's my application. I'm led by the learned ASG. This was an order Your Lordship had passed.
Yes.
Your Lordship sees. Your Lordship comes to page 15.
Insufficient to me. I am the petitioner in this matter. Your Lordship had passed this interim order after hearing all the parties.
Not hearing, Your Lordship. Your Lordship, it's my application. I shall place, then my learned friends could reply. Your Lordship, first, it's my application. Allow me to place that.
That's what I'm saying. Can you peruse it and then hear it? I have it. Order 39 ruled for second provision.
Yes.
Your Lordship, fraud unreveals everything. This order was obtained by fraud before Your Lordship. Why I say that? Port trust being, this is the affidavit of service, Your Lordship. If Your Lordship sees my application, page number 15.
Mr. Basu, giving the CPC in the morning, you have remind me my practice days.
That's right. That is the reason. That's your doing.
Page
Page 15 is Your Lordship's order.
50.
15. Annexure.
Yes.
Your Lordship, kindly come to page number 18 directly, wherein in the paragraph number
10.
10 and 11, Your Lordship has given them authority to construct.
Yes.
If Your Lordship sees the writ petition prayer, they did not even have they had not even prayed for construction work.
Where is that?
The writ petition prayer is at page number. Your Lordship, 22, it starts from 21, Your Lordship. It's renovation. If Your Lordship sees, renovation and restoration of plot number such and such. Restoration work. For any form of construction on a government land without a proper sanction plan, it's itself not permissible. What they had prayed, they have taken before Your Lordship in excess to what their prayer was.
First of all, madam, you tell me how you been affected.
Your Lordship. Your Lordship kindly comes to page number 52
Of your writ.
of my application. Annexure G.
Yes.
This is a notification of dated back on 14th of August 1909. If Your Lordship sees stone 1 on this description.
Yes.
The south side of Chandpal Ghat. The boundary, this is the boundary wall of Fort William. Fort William, Your Lordship, I would humbly pray that if the mic could be muted because it is very sensitive, it is relating to defense property.
Second him not with the bar, my lord, and whatever. Yes, madam. The lordship is trying my lordship's best, my lord, to accommodate all of us, my lord, but we need to cooperate.
After a very contested matter, my lord, I'm the society registered apartment ownership association, my lord, association. Now, my lord, there are so many flats. Now, in 2023, my lord, this association was formed. Now, every time, my lord, in 2014, my lord, 13 first election held for 1 year. Then 2014 up to my lord, 2016, that the tenure was for 1 year. Then 2017, that has been increased up to 3 years. We conducted the election, no problem. Up to my lord, only 2020 we could not because due to COVID. Then again 2022 for 3 years. Now problem cropped up in 2025 election. Now my lord, usually one of the learned advocate of this honorable court was the election officer who conducted the election with the help of the police and others. Now this time when we in the meeting held, some of the members said no, we will not agree with the name of that lawyer, particular advocate of our court, that he will conduct the election. Then we have no other alternative but to approach before the authority concerned. Now, authority is the competent authority as guided in the bylaws of the apartment ownership bylaws 2022. Now, my lord, first, my lord, I will show to your lordship, my lord, kindly straightway come. I'm telling you, lordship, kindly give me points because I need. My prayer is that there is a direction. Very well. I'm just making it shortcut. I'm making it shortcut. Kindly straightway come to my lord, page 27. On representation of 3 times, the order has been issued at page 27 by the special commission and the competent authority. But kindly see, the subdivision officer Barakpur is
page
27. He was directed July 25. July 25, considering the tension among the members of the association, the subdivision officer Barakpur about registered as election officer for conducting the election following the procedure as the West Bengal Department bylaws. Now, this has been communicated to the district magistrate as well as by subdivision officer by the competent authorities as well as special commissioner. After that, both subdivision officer as well as the district magistrate kindly did the question. He knocked down one, then kindly come to page 31. Again, my lord, 31 next 39. Again, the competent authority at the special commissioner directed the subdivision officer. But given a letter to us restraining us not to conduct the election, not to conduct the AGM. Kindly see that letter, my lord, page 44. This is the letter by the officer in charge, Khorda police station. Kindly see the last paragraph. Subdivision officer is not going to be person. The AGM is, we are trying to conduct restraining us. What I am praying before your lordship, let every deputy person or appoint any person from our court to conduct the election and the police will provide all assistance. That is only my prayer, my lord. And nowadays, 2 times order by the special commissioner, SDO, my lord, is not doing anything.
I'm concluding the elections expired in 2025. Now, in 2020, it is for 3 years. So, in 2020, it is expired. Now, as per Rule 6, it was the duty of the government to conduct and select the candidates for the election. They failed to do. They requested the competent authority. Competent authority requested SDO. Received an instruction from the SDO So from look at 60 months of the service.
Only thing is,
Okay.
only thing is, you have to follow the order.
16B. Section 16B.
Section, not rule. Still student.
Yes. Practical satisfactory. Should have performed functions of board managers. So board managers take submission, not subject to some
Section 39 of the bylaws.
May I just?
I'm sorry.
Why are you
Sorry,
interrupting
sorry,
like
sorry.
this?
আমার ভুল
I'm
হয়েছে।
trying to help. Why are you interrupting like this?
আমার ভুল হয়েছে। বোঝা বুঝতে পারিনি। Sorry to him also.
When you say sorry, don't use the word also. So, my issues. So, in my should not have been passed. Is that the market appoints somebody to conduct the election? Market appoints somebody to conduct the election?
May I
They will do that. They will do that. Those trying to cut short the cost. Now, if they want to pay, let them pay.
May I just? But my learned friend is saying, kindly see, that's why I'm showing to your the earlier page. Kindly see page 16. Before 16 of the liquidation. Before the expiry of the period, we kindly see page 16. Why, what?
Yes.
Yes. 39.
39.
May I, kindly see the bylaws.
Bylaws 39. Removal of difficulty also.
Yes, sir.
Removal of difficulty. Under what?
No matter what happened, if you actually see 39, but what is showing, but before expiring that, we conducted a meeting. In the meeting, some person says, kindly see once, because previous occasion, one lawyer, Mr. Nandi has to conduct the election. Now some of the members saying that no, we are not agreeable that. Now, the what total now, 48 total members and total flat owners is 198 and board members is 48 as 180. Sorry, I'm 1881. 8. 1181. 48. Absolutely. Election. Absolutely. 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 Now, when that I'm paying, I'm only paying that.
I don't mind. They will have to bear the expenses. I don't
will bear the expenses. President is here, kindly record, we will bear this. Kindly appoint anyone. Absolutely, absolutely.
Such a the election measure, he will declare election in terms of the balance, not for declaring this for declaring election. As per the 66, there has to be percentage. And now the election. Yes, in on that committee, he will absolutely.
All steps he will take
Absolutely.
as an election officer.
Or we don't
I'm not on that. I should not come before this court if the ballot SDO hear the order of the competent authority. 2 times letter has been issued. I don't know whether 39. 39 the competent authority can.
That's for yes.
39 by 39 or SDO. But kindly, even the SDO today, 2 times letter has been given to the district magistrate and SDO. But it has must be a cut scheme.
তুমি যা চাইছো তাই তো পাচ্ছ why are you making things complicated?
We will bear the cost. My president is here in the high.
1800 means it will be a big election, it will take time, so it has to be 188
1881.
These rules.
Total member is 81.
Can you look at it?
Kindly appoint.
8.
Absolutely correct.
1881 or 1881?
Initially it was 24, then it was increased to 48.
Bylaws came in 2022. So after that it was increased.
In 2022.
So bylaw 7
there is no dispute about that. Another thing only, your lordship is appointing officer. Kindly direct them at the officer in charge of the local police station to assist him, because there may be a chance.
One minute.
Kindly see, 848.
Mr. Mukherjee, you don't allow me to submit, and
very well.
Why are you so excited? Notice. I'm saying that. যাই বলতে যাচ্ছি তাতেই ঝাঁপিয়ে পড়ছে
অনেক সিনিয়র হয়েছিস
তোমার তো এবারে বলছি
অনেক সিনিয়র হয়েছিস আর আপনার লোক পেছন থেকে এক করে যাচ্ছে এটা সমস্যা না
কি জন্য আপত্তি করছে
বাইরে এখন don't be like that. Please don't be like that. Please don't be like that. Please don't be like that. অনেক বড় লয়ার ঠিক আছে না তো
করতে পারে না।
It is for 15 days. It was for 15 days.
Kindly make it 2 months. Election 2 months.
Yes. Well,
But then kindly make it 2 weeks, my lord. Instead of 10 days, 2 weeks.
Lord, my lord may make it clear that it requires special officer since he is a member of the bar, he can take police help, Lord. That he is not embarrassed. অন্তত 5 লাখ টাকা Yeah, it should be more than that. It is a huge task. Yes. Mala. Mala. Seven. Seven.
For the police station.
আমাদের But annual general meeting, special general meeting also because the term. Mile.
For the purpose of conducting the election.
Mile. Mile.
The election is clarified for the purpose of holding election. I think on that day, I'm sorry because I was in the hospital. That's why I could not. আমরা করেছিলাম হসপিটালে ছিলাম অনলাইনে ছিলাম
Well, 6, the learned addition advocate Mr. Razi Muzumdar is appealing, but he's requesting if it could be taken up any day during the week instead of today, because the matter has been very recently reported, and we need to take instructions. I'm only beseeching that prayer, before your lordship.
But the problem is, the entire hospital has been closed. There is no permission.
20th of July, it has been closed since then. But I'm not beseeching.
27th, there was an unfortunate incident.
The 4th of August, but I'm only beseeching to your lordship may be confirmed. Well, it's subject to correction.
Tomorrow.
In the meantime, আমাকে অ্যাপিয়ার করতে বলছে, পরে বলবে ইনভেস্টিগেশন কোঅপারেট।
We see after filing this petition by way of an email that we need to appear for an investigation. Let me from at least advices terms not to postpone this appearance.
That would
no, it's in department. Special investigation. I don't think it's an investigation. That has it made. Without has it made, then shares me to appear before.
Can it be taken up during day after tomorrow? I mean, because day after tomorrow, যদি করে দিই কালকে
অসুবিধা নেই
কালকে তো আপনার
আমি নেই
তাহলে ওটা তো থাকবে নিজের প্রচুর হবে only madam. But I can only beseech my learned, day after tomorrow I have requested. Day after tomorrow.
Maybe day after tomorrow, kindly pass this direction. But in the meantime, I'll not be.
Give necessary instructions subject to correction. Keeps it there. Yes, madam. Very well, madam.
এটা কোথায় দেখেছে সেম হচ্ছে একটু দেখাবেন আমাকে খুব দেখাই যাচ্ছে আপনাকে দেখতে পারবেন কিনা I'm grateful. Within 5 minutes.
Deep.
Submission of risky client. Well, I was appealing for the bank, well, I convened your lordships. Your lordship, the event, 4th of July 2025, the bank had given an offer to the petitioners to restructure the account under the MSME guidelines, and terms and conditions were there, but there is no response since 4th of July. So what? Now, lordship is still willing to give them one last chance so that they can apply. In that case, my lord, I was refused under some of the fate. That's my submission as a officer of my lord the
representing the bank. But since your lordship expressed lordship's mind, if lordship still feels that lordship is going to give them one last chance, kindly makes it an order of court, my lord. So far as others are concerned, lordship indicated that lordship will not. Yes. Absolutely correct, my lord. Right. And fixes a time within which the bank will respond. But my lord, please don't, my lord, direct status quo with regard to the other things. That would mean an interim order insofar as the enforcement proceedings are concerned. Because then tomorrow they go and once there is a high court order, it's very difficult to convince the tribunals. The tribunal feels no, high court has given some.
There has to be a status quo, my lord. Otherwise, while this is
I've only taken physical position. But for the next step after this would be saying there is a notice of 30 days. Which will provide me with I will dispose of its application.
no, the bank has decided it will reject. But one thing that we should have shown yesterday, when the department was writing to the director DSME, it had marked a copy to the bank even as on 17th of July, saying I'm entitled to the benefits and bank should look into it. Bank did nothing.
If that interim protection is well not granted, then that will create difficulty. Yes. So, my lord, it is for the first stage is bank would decide whether it would refer it to the committee or not. But later, if the bank chooses not to refer it to the committee, then it has a separate cause of action to come again.
That's it.
I understand. Then from the stage, it is well there.
That doesn't hurt him or me. Yes, I think that is. Yes.
So only for that period.
No, কি বলছে তোমার আবার মানে is not setting the clock back. Holding your hand, deciding, then it's starting again.
That I did not understand it, my lord. I have understood lordship's mind, but I'm still, my lord, thinking whether, my lord, this petitioner is entitled to such kind of a protection. To the extent he will apply, I have no issue if it is an order of court. But even if lordship does not give them this protection with regard to the enforcement proceedings, if the bank ultimately feels that they will consider and give them, naturally, my lord, they cannot, my lord, say they will definitely not be pursued enforcement proceeding any longer. I am only, my lord, trying to persuade the lordship not to pass an interim order. The bank is required. It's the writ petition pending till such time the first stage is not arrived at. Lordship sees how it transfers, and then lordship decides. They have been waiting since July 2025. If they have been so eager to apply under the MSME framework,
it's not about the timeline.
The entire practice is a standstill.
Yes. Yes. Committee. Yes. Yes.
If he's anyways saying that I'm not going to proceed, then the status quo, because it's an order of court granting it.
No, my lord, I was only, if I am proceeding under the MSME framework, and this application, if I take it to the level of the committee, then naturally the bank would not pursue that. But I am only saying that please don't pass an order of status quo with regard to the enforcement proceedings.
No, this understanding can be recorded. I'm not so keen about us. It's very clear he's going to reject it. But when an order of court is coming, then to allow a parallel thing to continue while he has an obligation under this circular, might not kindly allows me to because according to me, it's not to even this order. But I was well.
Lordship was looking at budgets yesterday, which quotes Malad Samarth. Kindly takes Malad Samarth paragraphs. Because otherwise the law is very clear. Whenever my lord it is a MSME enterprise, if he applies under the framework, banks will consider that is lordship's view also, and it is my lord supported by other my lord courts, my lord judgments also. When it comes to my lord, paragraph 9 of Vitra, which quotes Samarth. Paragraph 6 was placed yesterday. It takes paragraph 7 and paragraph 8. These are the two paragraphs I want to rely. As has been noted above, the petitioning enterprise does not seem to have ever claimed the benefit of the terms of the framework after the demand notice under 13(2) of the SURFACE Act. It is at the stage of compliance with an order passed by the relevant magistrate under section 14 of the SURFACE Act that this writ petition has been presented before this court claiming benefits of the framework to restrain respondent number 2 and its officers from proceeding further under the securitization and reconstruction under the SURFACE Act and other enactments except in the manner contemplated under the said notification. We find the benefits of the petitioning enterprise to be suspect. Pronix is a decision of a coordinate bench of this court holding inter alia that the notification is secured creditors. Finding to the contrary by the High Court of Bombay, judgment and order to the challenge was thus quashed. Stressing that the terms of the framework need to be followed by the lending bank secured creditors before the account of a MSME enterprise is classified as a non-performing asset. This decision also lays stress on the obligation of the MSME that it would be equally incumbent. This is the part I am upon. It would be equally incumbent on the MSME concerned to be vigilant enough to follow the process led by the said framework and bring the rights of the banks concerned by producing authenticated and verifiable document stroke material to show its eligibility to get the benefit of the said framework. It was cautioned that if such an enterprise allows the process for enforcement of security interest under the SURFACE Act, or having challenged such action of the bank creditor concerned in the court of law tribunal failed, such an enterprise could not be permitted to resist the process of law or actions taken under the SURFACE Act or at a delicate stage. This decision, however, last year is not important. But that's my observation. That the enterprise, the MSME enterprise has to be vigilant enough. In this case, the facts would show that the MSME enterprise is not vigilant because his first my lord stand with regard to my lord making an application under the framework in response to my 13(2) notice, which was dated 12th of September 2025. Since thereafter, there is nothing.
Let me.
My reply, the bunch which we handed yesterday, the representation under 3A was disposed of by a written document. In that valid as per 3A mandate of the statute, we have given reasons. Kindly comes to page 80 of the document, the top page numbers are there. Paragraph 10. Allegations made in paragraph 7 of your letter under reply are denied. With reference to 7.1, it is denied that classification of the account as NPA is illegal or arbitrary or in violation of RBI norms. You have not taken any steps in terms of the framework for revival and rehabilitation as provided in the scheme governing MSME. Now, if I read this minor sentence of name, with Samarth's paragraph 8, but it says not only MSME enterprise be vigilant, you would also file documents that affidavit and evidence to show how enterprise falls within the minor framework and how we can have the benefit. And it is not that only someone says this minor last judgment. The most recent judgment also says this. I didn't have that judgment. Just read one judgment says that. 28th of July 2026, versus Indian Bank and others. If the petitioner but made a observation, the quoted paragraph 7 and 8 of some. Judgments, this is paragraph 23 of your lectures judgment. Judgments related to petitions. The petitioners made request along with all documents. But as part of the request made by the petitioner, the bank issued notice declaring the account of the petitioner NPA. The petitioner requested the bank for consideration of the request of the framework for rehabilitation of MSME as per circular issued from time to time. But in the other case, petitioner never requested the bank for such benefit. 11 June, the bank has already taken symbolic possession of the property and published the notice in newspaper. But the facts of this case is similar. The petitioner accepts one strong sentence in the 33A reply that I am going to avail the benefit under the framework. But you have to take an application along with all documents and materials. With that affidavit, or the scheme. Take benefit under that scheme. In that situation, Samarth paragraph 8, your lordship's judgment in paragraph 23. The petitioner is not entitled to this benefit today because at the end of the day, the object is to thwart the enforcement proceedings which I have already taken under the SURFACE Act. He could have approached the court anytime before the first notice says that I want to take the benefit of September 2025. We are in July 2026. Much water has flown during this period. SURFACE proceedings filed, Section 17 filed, no status quo initially obtained, got vacated. I have taken physical possession of the property and it is with me. Physical possession taken.
While the writ was pending, they went into.
It is not the law that a pendency of it means.
Two things I'll just respond. Factually incorrect submissions. I'll show to your lordship. Please have a look at the 13-2 notices dated 14th of July 2025. There's a representation that is there at page 135, which is 25th of June 2025. There I have invoked the circular. Your lordship will have a look at page 135 once. Disputing the receipt of this letter. And emailed this also on 30th of June. And it's acknowledged also. At page 137, last sentence. Right, 137, your lordship will see the last sentence. We earnestly request your kind forbearance and seek revival support.
Email
Last sentence at page 137. Before the 13-2. Yes, my lord. Before 13-2, because 13-2 is 14th of July. This is June. 14th July is 13-2, page 156, my lord.
Which mail are you showing?
135.
135 to letter. মেলটা কোনটা দেখাচ্ছ?
এক মিনিট নিজেদের মধ্যে কোন আমি আমরা করে দিই। This is in June, where I've said that I'm invoking, please give me the benefit of restructuring under the MSME accounts. RBI guidelines for restructuring of stress. 13-2, my lord, is 14th of July 2025. At page at 158, left-hand column, bottom. This one that I showed to your lordship is 135. They are disputing having received it. Lordship will give me 1 minute. Oh, there is a receipt of this in my section 17 application. They've received it. I'll show that to you, Lordship. Received. Oh, 1st June. Yes, he is right. This was received on 1st of June.
June letter received on 1st of June.
1st June. Receipt 31st June. I'm sorry.
31st June नहीं.
31st June, 30th. There's a receiving. Anyway, this was emailed. One more thing, Lord. He doesn't have to get excited about the receiving thing. I'll show one more. No, my lord. 30 days in June. So 30th June, what about that?
No, it doesn't have to get into that. There is an email on 30th of June that has been made to them. This same thing. Please have a look at this because they were disputing that. Please have a look at this one. This will also precede the 13-2.
If I also may get a copy of this mail,
and actually document, Milord. This was.
I don't know whether this mail on page 135 is the same or not.
I also haven't checked. Email the 135 Act. This is the one. Gaurav, it's a simple question. Is this there? This is the same, na? Huh.
কপি দেবে না
লজ্জা ফেরত দিলেই তোমার আমিও তো নিজে দেখিনি এটা রিসিভিংটা দেখাতে পারছো না না ইমেলটা এইটা কিনা আমি দেখিনি দেখতে হবে Lord, can I just take that back once, Milord, and I'll trouble your lordship with another MSME reference. Milord, your lordship will just once have a look at another document which is there. Milord, please have a look at page 154. Ache. 133, yes. Even this email, my junior is right, even this email on 30th of June makes a reference to this, saying I am MSME, I have MSME registration, GST registration. কোথায় জায়গাটা দেখো একদম পেলার we humbly request for proposal processing. This is that. Now, one more thing, while your lordship needn't be troubled with that immediately. Page 154, your lordship has seen. This is 17th of July. 14th July is 13-2. 154, Milord, 154. This is Government of West Bengal, Directorate of MSME, writing to the Directorate of MSME, MSME Facilitation Council forwarding representation for intervention resolution of the petitioners. Please have a look at, Milord, the second paragraph. The NPA classification is questioned. The firm has sought, next paragraph after that, the firm has sought urgent intervention to reconsider the NPA classification, facilitate restructuring and revival under RBI guidelines for MSME. Now, Lordship will see who it is marked to at page 155. This is marked to the bank, recipient number 3. So it sounds very attractive to keep saying from the bar that at the last minute I've come. The bank sat on this. 154. One aspect, Milord, he's relied on your lordship decision. I'll just show one thing. The most distinguishing feature with that is your lordship, he placed from 23, understandably did not place 22. One line, Milord, I'll just place and I'll end there. In the present case on 4th March, this is the last judgment. Notice under 13(2) of the Act was issued by the respondent bank to the petitioners.
Totally, he has not given.
That's right.
Even he has approached the mediation, but he has not approached the bank.
That's the 13(2) also reply there was not there. And
even though he has not made your filing,
not requested that. And banks will not reply to my 13(3) objection. That possibly is not discharging their obligation that your lordship is now seeking to enforce through that. These are my respect.
The only additional document he cites is page 154. He says who is writing this and to whom. District Industry Center to the Director of MSME with a copy forwarded to me. Is this a requirement under the framework? If I put this question to myself, yes, my 153. That's 25th June. Yes. Yes. No dispute, my lord, it was.
There is no MSME reference.
There is no request for applying under the framework 135, which is not.
135 has it. 135 at page 138, specific reference. 137, specific reference at the bottom. It's sad that I'm not being able to show the receivings. Last paragraph, 137.
135, my learned friend possibly cannot rely because there is no receiving. So the other document which he can rely is page 133. I don't have a copy of that email which he is not trying to.
4th July 25, we have said as well as rejection cannot be considered favorable.
Don't do that. Don't do that.
This is the one.
George के देखो
I have opened it. No, yes.
we have a copy of a 4th July 25 document. If Lordship sees that,
37, the bunch of papers, my lord,
papers which will have a
page 37.
page 37.
গতকাল তো দিয়েছিল আমাদের
I'll give a copy.
তোমাকে দিয়েছি
দিয়ে দাও একটা কপি দিয়ে দাও
কালকে দিয়েছিল বোধহয় না
কালকে দিয়েছি
এইটা
this refers to a request made by the petitioner on 22nd June 2025 and a discussion that was held on 25th June 2025 with the credit team and high officials from bank regarding restructuring and releasing of further funds to your CC account. But after the discussion which is noted in the bullet points, kindly sees my lord, even as in July 2025, the manufacturing activity had not resumed. Then, my lord, hence, based on the above mentioned concern, delinquencies, your request to release of balance funds to your CC limit as well as restructuring cannot be considered favorably. That situation continues even today. The manufacturing unit is closed, but there must be a purpose behind giving this enterprise an opportunity to avail under the. Well, I am still, my lord, said it. I was only, my lord, saying that giving an interim order of status quo. Till the time I decide on his representation, whether it would be referred to committee or not. Very well. What should does that?
Grateful to you. But let me.
না যেতে দেবে না সারা সকাল আমি শহীদ হয়ে গেছি
পেজ নাম্বার গুলো বলে দেবে তো বাট the sanction letter is dated 6th of June 2024. That is the second sanction letter. Yes, that is not annexed to Lordship. 2022.
7 December 22.
Six crores. 6 crores. 6 crores. It's 600 lakhs. So 6 crores.
6 crores.
Because then I will go out of the ambit of the MSME.
Can't be a MSME.
Yeah.
Section 7.
One last contention, documents and materials which are required to accompany that affidavit, that has also not come.
Yes. Yes.
No, not received. Received.
Yes, I will just give my learned senior a copy. और तो पति ही देते।
Item number 8.
But item 8, I appear for the petitioner. Dear Lordship is aware of this fact, but I'm in custody for last 21 years. And but three of us, my brother,
My lord, his name is already in the list, my lord, for 77th meeting, my lord. My lord, that date has not been conducted. My lord, 76th was held.
The records are before it is Joseph that by
These two matters are also running in this list, my lord. Item number 23 and 52, my lord.
three of our family members are there. My brother expired. His wife name has been there, but she has been released. If your Lordship can have a look to the handwritten page 4. Top. Handwritten portion, page 4. Padma Roy. But, yes. Page 11. Handwritten top, page 4. First name is Padma Roy. Wife of Ratan Roy. Ratan Roy is my brother. Padma Roy has been released. Now, she was released in 2024 after undergone 15 years of actual imprisonment. Yes. The records I have annexed. If your Lordship kindly have a look to the release order, page 2.
Torun Roy.
He is one of the accused. No, his name is not there. I made a. No. This is.
No, my lord, the coming meeting is 77th meeting, my lord. That
6 years have gone.
My lord, yet. 77th meeting, his name is there. My lord. Meeting has not been held yet. Yes, my lord. Yes, my lord. Yes, my lord.
6 years have gone.
My lord, then consider. Then consider the. My lord.
Lordship.
My lord, as per my instruction, already.
July. The matter has been filed in January.
My lord, on earlier occasion, London Additional Advocate General was appearing, my lord.
Whether the principal secretary of the correctional administration department is a party. That's for number 2. Your lordship will direct them.
Yes, my lord.
I have to see whether what is the date of the meeting. If that meeting and whether the state was considered or not, then
My lord, pending before the state, my lord.
when after the what is that? I know when you have taken the decision, given the multiplication, whether it was state and whether the state they will not keep the pending. You have the guidance.
No. My lord. May I come back then? Then may I come back tomorrow with my lord's order? Achha.
My lord, just 1 week, my lord, time.
Lord, may I request your lordship my lord, to direct respondent or 2 minutes to file a report before your lordship. My lord, he is the until and unless your lordship is aware, my lord, in an order of the court is there, my lord, the department will not wake up. Naturally. No. Brought to the principal secretary, correctional administration department.
Correctional administration. But as per the instruction, the principal secretary department of home is the chairperson, not the correctional home, my lord. Correctional administration, my lord. That is the main problem, my lord.
Then date of birth?
76. 2021. And the Department of Home.
But I made the principal secretary correctional administration department as a party, and the principal secretary of the governor. Well, the release order has been passed by the. But then kindly grant me leave to make the home secretary a party.
Correctional administration.
Well, it is the principal secretary of the Home and Hill Affairs, Government of West Bengal, is the chair. He is the chairperson of the State Sentence Review Board.
SSRB board, man. Chairperson is the SSRB board. Is principal secretary of Department of Home, man. Not the correctional administration, man.
Very well, Malad. I'll make him a party. Malad, can he pass that order, Malad? I'll make him a party with the leave of the court. With the leave of the court. Department of Home and Hill Affairs. बोलो ना, लेके क्यों गई? काट दो.
So, I have got the instruction from the department, my lord. Principal Secretary, Home Department is the chairperson, not correctional administration. That is.
Leave may be granted to Adima party. Course of today. Great.
Item number 9.
But on the last occasion, my lord had been pleased, my lord, to direct us, my lord, this related, my lord, to the tender of the Asansol District Hospital. But had been pleased to direct us, my lord, to come up with the tender documents. My lord, yes, my lord, these are online documents, my lord, these have been printed, my lord, from the. My lord, these are on, yes, my lord will be pleased to take, my lord, page, my lord, 16. My lord, first, my lord will please to take page 13, my lord. Page 13.
A copy of the original bid document, what they're relying, my lord, may be given to me.
My lord, page 13. My lord, this shows, my lord, this is the certificate of enlistment, the trade license, my lord, which we commonly call. My lord, this is for their, my lord, fourth line, my lord. Profession, trade, or callings or other enterprises category, printing and office stationery, which is the nature of business. I'm sorry, madam. Page 13. So, madam, this related, madam, this tender related, madam, to a food-based thing. So, does not essentially, madam, relate to, madam, printing office stationery. Madam, this was the first, madam, canteen services. Madam, canteen services, madam. Canteen services, madam. So, this is, madam, where they submitted, madam, the trade license, madam. Yes, Malad, this is one. Next, Malad will be pleased to take Malad, page 14. Malad, this they have submitted Malad an FSSAI license in the name of Malad, person in charge of operations, Malad one Bondona Rai. Malad, this is not the person. Malad will be pleased to take Malad, page 16 here. Malad, this the set which I've handed over, Malad. Malad, page 14, Malad, have been pleased to take the. Yes, page 14, Malad is in the name of Bandana Roy and 16 is in the name of Niharanjan Paul. So, Malad, there is a discrepancy as far as Malad, who is the authorized person, Malad, to act. And since Malad, the tender had fallen below Malad 3 persons, so Malad, a fresh tender. So, and they have not also been operating since now, Malad. So, right now, no equity exists in their favor, Malad. Malad, it has been issued, Malad, afresh in the name of Malad. Fresh tendering has been called for. Well, this is a long time.
My lord, first of all, this is not the entire bid document. And this is a. Yes, this is not the bid document, my lord. Kindly come to my. This is the entire bid document which I have annexed with my supplementary. This is not the bid document. This is highly. I should not say. Learned Standing Council of the state is addressing. 13 and 14 I have seen. This is pertaining to the another tender document which was cancelled earlier. And this tender document, my lord, bid document which I have uploaded, that is starting from the page 10 of my supplementary.
Page 23, my lord. My lord. My lord, page 20 of the writ petition, my lord. My lord. My lord. My lord. My lord. In the name of my lord, Bondona Roy. Yes, my lord. My lord, page 13. Oh, yes, 13. Yes, my lord. My lord. My lord.
The same thing. Same thing.
My lord. No, 114, my lord has taken, my lord, the document which I've handed over. My lord, that page 14, my lord takes. Yes, that is 15. So they should have given, my lord, the page prior to 114. That they have not given. 14 and 15 is one composite document which I've handed over. Now my lord takes 114. 114 is there, and then 117. 117. So it's in a different name, my lord. Yes. My lord. My lord, valid trade license. Yes, my lord. My lord. My lord. No, my lord, 38 is the FSSAI, not the trade. Yes, his 38 is FSSAI.
No. Trade license. Yes.
38, my lord, of
Supplementary.
writ petition is FSSAI.
38 supplementary.
Yes, I am there, my lord. It's of then that is, my lord, of the this thing of the supplementary affidavit. The thick one is sir, my lord, my lord. Yes, my lord. My lord.
It is a trade license. It is in the name of the United Order and Supply Cooperative Society Limited.
My lord, very well. My lord, this tender, my lord, was issued on 23rd April 2025. This trade license is valid till 23rd April 2025.
No.
Page 38. My lord has seen. My lord, this certificate. My lord is at page 38, my lord. My lord, 38 is the permanent certificate of enlistment, my lord. Page 38 of the writ petition, my lord, is the FSSAI, is the food safety standards. That is not the trade license, my lord. That is the food one.
Trade license at page 38.
My lord, is the
38.
supplementary affidavit.
Sir, come to page 33, 23.
23. Yes, 23.
Come to the folder 2, page 23, folder 2.
Yes, folder 2.
Yes. II. Food license.
Food license FASI.
Where is that?
That is at 114.
114.
Food license. Food license FASI is 114.
I am asking the
Yes.
with regard to the II.
Yeah.
Come that
114
of the
supplementary
affidavit.
thick one.
Correct.
Yes.
114
of the supplementary affidavit.
My lord, 114 to 119 is the complete document.
Complete document.
So 117 is what we are relying upon.
Yes, 117 is in the name of Bandana Roy. So how the Bandana Roy license?
My lord, this license was issued in the year of 2021. Kindly.
Correct.
So Bandana Roy was the secretary at that point of time. And this license is valid till 2026.
Where is that?
My lord, that will be, my lord, that is on the page 114.
114.
114, that is valid up to 3rd August 2026.
So okay, on the date of your bid, that you are relying upon the 114. You are creating your own problem. So why you disclose that 117?
My lord, this is the entire complete set of document.
Okay. So what is the difficulty, Mr. Chatterjee? 114 is the valid document.
Yes.
Then
117 names someone else.
117 might be, but on that day,
yes,
when your tender was when the tender was published.
23rd April
2025. 23rd April 2025. This page 14 is valid.
Page
114.
Yes, but 117 is not valid.
Not that.
Yeah.
You have to.
Tenure is valid. Yes.
Tenure is valid.
Tenure is valid. Yes.
And my lord,
If we leave aside the Bandhana Roy,
Tenure is valid.
tenure is valid.
Yes, yes,
Correct.
absolutely.
So
Tenure
one, so one is okay.
My lord, one is okay, but Bandhana Roy we have
Leave aside.
for a moment here.
Leave aside because Bandhana Roy, if considered also, because kindly come to the 117, that is only 2021, not 2028.
yeah, 2020, not 2026.
No,
Five.
so this is issued on 2021 for 5 years.
5 years.
But Bandhana Roy. That is why we have
At
instructions.
that point of time, she was the.
Please. Correct.
Correct.
Now come to the second license.
My lord.
Trade license.
My lord.
Trade license is 38.
My lord.
Trade license is 38.
Yes. 38.
Now 38 in the name of the petitioner.
My
There is no problem.
No, my lord,
That is
there is
also-
a problem.
What is the problem?
Trade license is in force till 23rd April 2025. So
No.
it was
No, kindly come 38 of the writ petition. Now you are telling.
no 38 of the supplementary.
Writ petition.
38 of writ petition is food again. So it's done. 38 of writ petition, my lord.
No, 38 of the supplementary.
No, confused.
38 the supplementary.
Yes.
Yes, this is.
That's why I am. Yes, now come to 38.
Yes. So, my lord, the last line on this page, my lord, to the middle of the page, my lord, I'm sorry.
Renewal date.
This certificate of enlistment is hereby renewed and will be in force until 23rd April 2025.
Yes.
So, the tender was of 23rd April 2020. So, it had expired.
No, it was on the date, my lord, and it is produced at the time
How
of
will they do
further.
Where is your extension? Because kindly see date of renewal April 2024 and it was extended till 23rd April 2025 and the tender date is on 23rd April on the very same day thereafter.
Milord, it has been already extended, Milord. I shall produce the document.
Not produced, but
Milord,
on that
on
day.
the- on that
Okay,
day it was
then
on the date of
then PAN card and PAN card.
So, my lord, also, my lord, we'll come to page 13 of the documents. For a moment, my lord, I'll just trouble my lord. Page 13 of the documents which I've handed over.
No, kindly first list you
Oh,
complete
no,
the
my
list.
lord, just the trade license. I want to show it once.
That is,
He did not submit this trade license.
which one?
My lord, page 13 is the one which they submitted, of the one which I handed over. That's why, my lord. Just to. So they submitted.
Page 13 of their document.
So this is not submitted.
This, yes. My case is that they had submitted page 13 of my document.
This is not the document.
Not the document.
First of all, Milord, this
My lord,
is,
and my
this is
You tell me only one answer. Page 37, if your affidavit, the supplementary affidavit, and the document which they are submitted, that is a different document.
Milord, this is a different document.
You are not submitted this document. You have submitted this document.
Milord, this is actually, Milord, not uploaded document, Milord. First of all, this
Record an order. The
Milord,
petitioner has filed the present writ application challenging the
Milord, this is not the entire tender document, Milord.
challenging
Document.
the termination of the contract dated 23rd of April 2025. Learned Counsel for the state submits that. Learned Counsel for the state submits that the petitioner has not submitted all the required documents in terms of the tender notice dated 23rd of April 2025. The documents which the petitioner has submitted that are contrary to the documents which are required. He further submit that the after the technical bit, it was found that only
my lord, less than 3, my lord.
Less than 3 bidders have participated in the said tender.
But only 2 were.
Only 2 bidders are qualified for the said bid proceeding. And as such, the authorities have cancelled the said tender notice dated 23rd of April 2025 to give further competition to the eligible bidders and publish a new tender notice.
My lord,
have you published a new tender notice? No.
Well, yes.
And published the new tender notice.
The tender was cancelled.
That was cancelled.
On 21st May 2025.
Tender was cancelled, but no tender NIT was invited.
2025. 2025.
My lord, 21st of May 2025.
2025. Now new tender has not been floated.
That instruction specific I have not received.
Consider the submission made by the counsel for the petitioner. By the order date, counsel at the Land Council for the respective parties. By the order dated 22nd of July 2026, this court has directed the respondent authorities to place the original bid documents of the petition along with all documents which have been submitted by the petition along with the bid. The respondent authorities have submitted the document wherein it reveals that the enlistment certificate which the petition has relied upon in the present writ application has not been submitted along with the bid document. The bid document, the petition has submitted another document in the bid document, other document in the bidding process. This court also find that the petitioner has submitted the enlistment certificate in a FSI license. The Bandana Roy,
my lord, FSI license. FSSAI.
is submitted the FSI license in which one of the license is in the name of the Bandana Roy and not in the name of the petitioner. The enlistment trade certificate which the petitioner has relied upon, that trade certificate has been issued to the petitioner for other enterprises category, that is printing and office stationery within bracket nature of business, and not with regard to the supply of food. Considering the above, this court find that the respondent authorities have already taken a decision for cancellation of the tender, and thus this court did not find any legality for cancelling the tender according to WPA number 767.
Milord, before parting with the matter, Milord, kindly have a look to their document page 3, Milord, once, Milord, page 3. Kindly have a look to the page 3, Milord. Kindly have a look to the page 3, Milord. This is a, Milord, the split document, Milord, not the entire bid document.
So your lordship switches over to the SIR matters, but item number 13 is mine. But in the second half, I'm in some difficulty with my
36.
13, 1, 3. Well, my learned friends for the respondents are here. If your lordship may kindly take up this matter tomorrow, Milord, subject to Milord.
13.
1, 3.
Who is for the other side? Okay, 13 not today. 13 and 14 both.
Both. Kindly fix the matter.
Not today, huh?
May it retain its position. Stop, my lord.
Number 10.
What?
Item number 10, your lordship. I was
come after lunch. Yes.
Lordship will be kindly keep it tomorrow, your lordship.
Call the list.
I am for the petitioner. The appeal were DO. Lordship, he applied for passport on 2nd of April, and its date was fixed for rescheduled on 21st of August, your lordship.
Yes. Where is the appeal?
Page 45, your lordship.
In terms of pair G, page 24.
Page 45, your lordship.
Right down from pair G, page 24. Issue a read in the nature of anonymous that respondent passport of the person to not treat the original passport application as national authority events pending final disposal of the statutory appeal before the district election.
Where is your appeal?
Appeal page 45, your lordship. Appeal before the DEO, district election officer.
Record or not? The petitioner, the name of the petitioner has deleted from the voter list, and accordingly, the petitioner has preferred an application before the district election commissioner for consideration of his name of illegal deletion from the electoral roll. The petitioner has filed this representation before the district election commissioner on 5th of March 2026, but till date, the district election commissioner has not considered the application submitted by the petitioner. Yes, what is the urgency you're telling?
Passport, your lordship.
The council for the
rescheduled on 21st of August, your lordship.
The petitioner has applied for issuance of the passport, but deletion of the name of the petitioner from the voter list, the passport authorities have have not considered the request of the petitioner for issuance of passport. She submit that the direction may be issued upon the passport authority, and direction may be issued to the district election officer for disposal of the appeal dated 5th of March 2026, and the passport authority may be directed not to pass any order till the disposal of the appeal by the district election officer. At the learned counsel for the parties, we find that the petitioner's request for reconsideration of the name for including his name in the voter list is pending before the district election officer. According the district election officer, Murshidabad, West Bengal, is directed to consider the representation dated 5th of March 2026 by giving an opportunity of hearing to the petition to pass a reasoned and speaking order within a period of 2 weeks from the date of receipt of this order. Till the decision is taken by the district election officer, the passport authorities are directed not to pass any adverse order on the application submitted by the petitioner.
Obliged.
Disposed of, huh? It is separate of it. Next. Appeal.
But appeal file, huh?
Page what?
Page malad.
Dispose of.
Appeal file.
Give your name.
Malad.
I will not correct any name in future. If today they will not give the name.
Malad.
But they are missing out my name.
You give your name in all matters.
Or similar matter, malad.
59?
Similar matter, malad.
No, appeal is there.
Yes, malad.
Dispose of.
60? Page 41 of 40.
Disposed of.
61 taka. 61. I'm for the petition.
61.
I'm for the petitioner. Page number 34. Appeal.
Disposed of.
Page 45. Page 45.
Disposed of.
I'm for the petitioner. 21.
Disposed of.
My lord, the petitioner is under adjudication.
Leo.
Leave be granted to file Form 6, fresh application.
Under adjudication, where?
Under adjudication are those cases wherein the judicial officers are
Not
given
pass
to
an
the
order.
effect. So it is better she files a Form 6, new epic number would be generated.
How it can be?
Yeah.
It is submitted by the learned counsel for the petitioner. The request of the petitioner is under adjudication. According, the petitioner is given liberty to file Form 6 within a week. Within a week. Form 6.
Form 6 within 2 weeks.
Within 2 weeks. And if the petitioner submit the Form 6 within 2 weeks, comma, the competent authority. Who is the competent authority? EO. The competent authority, that is the ERO, shall consider the request of the petitioner and to pass appropriate order within a period of 3 weeks thereafter. Yes, next.
37. Your Lordship, yes, I am appearing on behalf of the petitioner led by my
37.
senior.
Disposed of.
Page 50.
Disposed of.
67.
67.
Is my appeal.
Appeal is there.
Appeal is there. The page number is 17.
Disposed of.
I said 68.
68. Epic number. Physical appeal. Epic number. Fine. Epic number.
Page number.
Your Lordship, there's a physical appeal which is at page number 3. A physical appeal is there, you know. 30. Page number 13. The epic number may be mentioned in the order copy, so they will be able to track that.
The petitioner has filed physical appeal being agreed with the as the name of the petitioner has been deleted from the voter list, according the petitioner has preferred a physical appeal before the to whom?
Before the district magistrate, DEO.
Before the
Purva Bardhaman.
Before the district magistrate.
Purva Bardhaman.
Purva Bardhaman. Purva Bardhaman. Bardhaman on what is the date? Purva Bardhaman being epic number YWL 2348332 and the same is pending before the concerned authority. In view of the above, who is the authority? AERO? The AERO.
This will be the SIR tribunal.
SIR tribunal. The SIR tribunal is requested to consider the appeal of the petitioner being epic number YWL so and so and to dispose of the same as early as possible, preferably within a period of 3 months. Next.
That's why for the petitioner, the appeal is on page 42.
Dispose of.
As a 69.
Disposed of. Yes, next. Disposed of. Next.
The appeal page 20.
Page
20. Disposed of. Appeal. Disposed of.
Page 24. Appeal 20.
Disposed of.
Number 37.
Your Lordship,
Disposed of.
Your Lordship, kindly pass and time-bound manner, Your Lordship. The petitioner has an invitation from the Imperial College of London and research of Your Lordship. He has to complete.
Where is the document?
Document is at page 13, Your Lordship. 75. 75.
Honorable Court. 75.
75, page number
39.
Where is the document? The petitioner has preferred an appeal. The name of the petitioner has been deleted from the voter list. According, the petitioner has preferred an appeal before the appellate tribunal on 3rd of April 2026 and the same is pending. Then counsel for the petitioner submitted that the petitioner has received an invitation letter from European Research Executive Agency within bracket REA, for agency, UK, but due to the deletion of the name of the petitioner, the petitioner is not in position to join the invitation. Accordingly, he prays for the direction upon the appellate tribunal for disposal of the appeal as early as possible. Consider the submission made by the counsel for the petitioner and the invitation letter received from the European Research Executive Agency UK, the appellate tribunal is requested to dispose of the appeal filed by the petitioner as early as possible, preferably within a period of 2 weeks from the date of receipt of the order. Yes. Disposed of.
Lordship, I'm for the petitioner. Page 25 is my appeal.
Disposed of.
Page 107.
Disposed of.
79 is my matter, Your Lordship.
You are appealing for? Disposed of.
Page 57, Your Lordship.
Item 80, my lord, I am for the petitioner.
Disposed of.
31, my lord. Here is the petitioners, the same family.
How many petitioners?
Petitioner 5, my lord. 2 are brothers and
pay the court fee.
Lord, if your lordship permit, my lord,
then I will not sign. You pay the court fee and give that.
My lord. Disposable.
I will not sign.
In course of this day,
Item number?
80.
Yes.
80.
Pay and give the receipt to my court officer. Yes, next.
So 81 for the petition appeal is at page number 26.
Disposed of.
I am for the petition, my lord. Page
Disposed
number
of.
29. Page number 29.
ये আছে না আছে appeal আছে अरे आप क्या करते, आप निकालते क्यों नहीं, आप क्या करते हैं, निकाल के दिया करो ना। None moved, no accommodation, dismissed. None moved, no accommodation, dismissed. Next.
To 84 petitioner, paid the court.
Disposed of.
My lord, 85, I am appealing for the petitioner, my lord. Page number 14 is the appeal.
Disposed of.
My lord, I am for the petitioner, my lord. I have page
Disposed of.
My lord, page number 14, my lord. I am
Disposed of.
My lord, I'm for the petitioner, my lord.
39.
Disposed of.
My lord, I'm for the petitioner, my lord.
Disposed of.
My lord, 90, I am for the petitioner, my lord. Page 14.
Disposed of. 91.
Go back to sleep.
Dismissed. Disposed of. Next. 92.
92.
Yes. 92. Who is there? 92.
No, petition is not same as 90.
Disposed of. Disposed of. तो है बोलती है। Disposed of.
95 was already disposed of.
Already disposed of. Out of list. Delete from the list. Already disposed of, huh?
96.
96.
Disposed of.
60. Is a pension, he retired on 30th September.
Delete.
Fresh matter. The petitioner is retired on 30th
Which one?
September. 96, your lordship.
You are telling that disposed of?
Kindly dispose it of.
What about the 95?
95 was previously order was passed.
Okay, 96 disposed of.
In 96, the petitioner retired on 30th September, your lordship.
30th September.
Yes, lordship.
So what you?
Date vote बोले की होगा appeal page बोलना.
Page 60, so little
Page 60 sir.
95, 96. Huh? And counsel for the petitioner submit that the petitioner is a government servant and is going to be retired in the month of September 2026. But due to and separate for expeditious disposal of the appeal pending before the SIR time. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to dispose of the appeal as early as possible, preferably within a period of 2 weeks from the date of case. Yes, next.
My lord, I'm for the petitioner. Appeal at page 19.
Disposed of.
36.
Disposed of.
51 next one.
51 page number.
Disposed of. 101 Tarjeen.
There's a previous order made by your lordship. Despite your lordship.
Because nobody appeared. Until unless my learned friends provides a scanned copy, I cannot provide it to the
It is my mistake. Everything is my mistake. Unfortunate thing is that despite bringing it to the notice of the nodal officer, not steps have been taken to.
So where is the order?
90.
90.
So this is the instance of an applicant practicing here.
I'm not going to the tribunal.
Yes, yes.
So what is the order?
Yes, please.
Dispose of the requesting tribunal, consider the file by the appeal after decision be within accordance with law.
The notice of the tribunal.
So what has happened? No.
Nothing has happened thereafter.
Not disposal.
Yet to be disposed of. We have made a representation on 8th of June 2026 to the nodal officer as well as bringing it to the notice of everyone.
Record an order. By an order dated 17th April 2026, this court passed an order by disposing the WPA number 9475/2026, requesting the tribunal to consider the appeal filed by the petitioner for taking appropriate decision in accordance with law. Counsel for the petitioner submitted that the order was duly communicated to the tribunal as well as the nodal officer, but till date the tribunal has not disposed of the appeal filed by the petitioner. Counsel for the petitioner submit that the petitioner is a practicing lawyer and is intending to go for the Hajj, and he prays for expeditious disposal of the appeal. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to consider the appeal filed by the petitioner as early as possible, preferably within a period of 2 weeks from the date of execution. Next. और कौन टाइप कर जब जो टाइप कर
31 for the petitioner, appeal at page number 93.
तो दूसरा एसएसएस आई कुछ है एसडी उसका सीधा टाइप कर दो फॉर्मेट में हम जल्दी था कर साइन कर दिया पर अच्छा नहीं वापस करें यस 101 होगा अच्छे
I'm for the petitioner, your lordship, page number 93, appeal.
Disposed of.
DO appeal page 50.
Disposed of.
DO district election officer.
Where? 100. Where is the file?
Page 50.
Page number
50. 50.
The petitioner has filed an appeal before the district election officer Nadia Krishnanagar against the deletion of his name from the voter list, but the district election officer has not considered his request till date. She pressed for an order directing the district election officer Nadia to dispose of the appeal filed by the petitioner as early as possible. In view of the submission made by the counsel for the petitioner, the writ petition is disposed of by directing the district election officer Nadia Krishnanagar to dispose of the appeal filed by the petitioner dated 10th March 2026 after giving an opportunity of hearing within a period of 3 weeks from the date of receipt of this order. Next. 104.
My lord, I am for the petitioner, my lord. The appeal is on, my lord. There are 3 appeals on page number.
Disposed of. 105.
105. My petition. It's appeal page 56. Your lord.
Disposed of.
106.
My lordship.
106. No appeal nahi.
My lordship. Deleted. We go before Calcutta.
Deleted from.
He has to
Deleted by whom?
During SIR proceedings in month of March itself, she was deleted under adjudication.
No, deleted.
She has to file a form 6, fresh form 6.
Appeal for restoration, district election.
Number 13 is the
Page number 15 is there. District election officer.
DEO, Kolkata.
Appeal is pending. 14 also DO. Correct. The petitioner has filed an appeal before the district election officer against the deletion of her name from the voter list, but the district election officer has not considered the representation made by the petitioner till date. He prays for a direction upon the district election officer for consideration of the request made by the petitioner dated 11th of April 2026. Consider the submission made by the counsel for the petition, the district election officer, Kolkata.
Yes.
Kolkata is directed to consider the appeal filed by the petitioner, consider the representation filed by the petitioner dated 11th April 2026 after giving an opportunity of hearing to the petitioner to pass reason and speaking order within a period of 3 weeks from the date of receipt of this order. Next, 106. 7.
I'm for the petitioner. Page 47 is there.
Disposed of.
I'm for the petitioner.
Disposed of.
109 for the petitioner.
Disposed of.
Appeal before the DEO, district election officer. Page 40.
Same as 106. Order लिखे ना order.
But date.
But date.
Appeal date क्या है?
Now 4th April 2026.
Same as. Disposed of. Which district officer? Which district?
Actually, back sheet is that district level.
District Murshidabad.
Yes, next.
I am for the petitioner.
Disposed of.
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 I am for the petitioner. Appeal page 38.
Disposed of.
My lord, I am for the petitioner.
Disposed of.
Has. Your lordship paid 115. She has to pay court fees. Uttar Dinajpur within 2 days.
Others.
Others. How many? 7 people.
Pay the court fee.
Family.
Huh? Who are the 7 people?
Within 1 day. Today I.
Who are the 7 persons?
Family members.
Disposed of. Court fee also. Next. 115. Court fee not paid. Pay the court fee today. Yes, next.
116.
See the file. Appeal flag kori ni. Disposed of. Next.
117.
Disposed.
Lordship, I am for the petitioner. Lordship, I am a doctor by profession, Lordship. That is my only urgency, Lordship. I am a government.
What is the urgency about doctor?
Lordship, he is facing government employee, Lordship. He is a government employee.
38 is the appeal.
Page 38 is my appeal, Lordship.
18. Now, counsel for the petitioner submit that the petitioner is a doctor by profession, but due to the deletion of his name from the voter list, the petitioner is not getting benefit, and as such, he prayed for expeditious disposal of the appeal before the appellate authority. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to dispose of the appeal filed by the petitioner as early as possible within 2 weeks from the date of. Next.
Lordship, I am for the petitioner, Lordship. Lordship, 28 is my appeal, Lordship. She has passed West Bengal Nursing Council examination, Lordship.
Let's go on. Next.
Grateful, Lordship.
Next.
Appeal.
Disposed of. Disposed of.
Already disposed of on 1st August.
Disposed of. Delete from the list. Next. 23.
Item number 123. And for the petitioner, page 24 and 2011, there is half agency has got some opportunity to serve as a minutes. So
Where is the invitation?
the invitation is not there.
Then-
As well.
Disposed of.
And the order is also mine, page 21.
Your Lordship, for 79, there will be a different order distributed back to the capital.
Deleted the.
79.
79. Excluded on 12th of May from the tribunal without hearing.
79.
79.
Restore the appeal. 79 A order. Yes.
but at that time, my clerk is here, but I'm not here. So my name is not.
Which matter?
SIR.
Give the number and.
My lord, under compelling situation, I am before your lordship, my lord. My lord, this is the two SIR matter, my lord, because urgency is that, my lord, the petitioner participated in NEET examination. He under the OBC category. My lord, the petitioner domicile certificate and, my lord, the ANC certificate, non-criminal certificate is required. My lord, counseling date is, my lord, 13, my lord. 13 August. My lord, it needs to, my lord, non-criminal certificate and domicile certificate is not issuing. The reason is that the handling is dictated from the, my lord.
You want?
My lord, hearing of these two matter, my lord, as early as possible and in direction upon the, my lord, authority to decide. Grateful, your lordship.
Lord, item 34. Lord, this is your lordship's last order. Lord, the interim order is there till today. They have preferred an appeal. My lord may recollect that. Lord, so cause matter of sale, where the appeal Joseph Kedin order. Lord, 34. My lord, the appeal is pending. My lord has extended the interim order today. The appeal is also listed today. So my lord may first page only the order. Second page is the notice. My lord may extend the interim order, my lord, till the appeal is decided.
Which item number?
34. My land firm is for the sale. Mr.
Yes.
Banerjee.
Till September. If appeal will.
The appeal below Justice Banerjee will be in circuit. What I have heard below Justice Banerjee.
The appeal is appearing before the Honorable Division Bench presided by my lord Justice Arijit Banerjee. Justice Banerjee would add on the circuit bench of Jalpaiguri from 10th of August, I believe. That is what he is saying. Right?
Till 24th of August, he is not there.
So that till end of September, or khushi hoy baba. Whatever he says.
Item number 30.
34.
The first week of September.
34. Though the matter is listed as item number 34 on days list, but the London Council for the petition mentioned the matter and submits that the matter is.
Will not kindly record my object.
Interim order is till today, and paid for extension of interim order. If further submitted, the respondents have preferred an appeal, and appeal is pending before the appellate court. And counsel for the respondent raise objection and submit that the respondent already preferred an appeal, and the interim order is extended, it will affect the appeal filed by the petitioner respondents. At the land counsel for the petitioners, counsel for the respective parties, this court find that the petitioner already enjoying the interim order extended till 17th September 2026 or until further discovery earlier. Let the matter appear on 17th September.
Yes. Well, is that notice in the order so that it could be tagged with the file or file tag was Joseph ke dekhiye diyo na.
Yes, next call the list.
No, it will appear. 17th September it will appear. Grateful.
My application.
This is just simply on an issue of law. Lordship, I am appearing for the private respondent. Lordship would kindly take it up tomorrow, Your Lordship.
Why?
Lordship,
My essential prayers are against the ROC. There is a board resolution that has been taken behind my back. The Companies Act has not been followed. I have written to the ROC. The ROC, I'm covered by a lordship decision. It's just ROC will give me a hearing and this impugned board resolution will state whatever the private respondent has, he can go and take it up there. Your lordships have allowed that and directly covered by the judgment of your lordship. But it's a simple thing.
No, henceforth I will not pass any. I will keep all the things pending.
So we don't come back with.
But that would kindly keep it for tomorrow. If we have a copy of that order, we can come up and.
It's a reported judgment. Why would you give a copy of?
Well, you know which judgment? I know.
On adjournment.
Court has not decided an issue, only directed to.
Yesterday it was called on. My friends were not here.
Nobody was here.
He doesn't know whether he should not speak. I was here, Lordship had kept it for November 20. I don't know how it has come up as urgent motion as a motion item number 10. No notice, nothing. This is type of practice, Your Lordship.
Respondent.
ROC and the company.
Issue notice to the ROC.
No, let them. We want to not issue any notice.
Why does he get aggressive?
Well, the way speaking, Lordship, I was
Not having lunch.
So I don't know what is that for lunch. I had idli.
First hour, 10:30 to 11, you are having this one.
Again 2 to 3.
10 to 2:30.
Other way.
Whatever you lose your energy, then it will come down.
Lordship, as a general lordship, I try not to eat anything from morning 10 to till 4 o'clock.
Good.
The ROC, we've given notice. Everybody
So,
received.
Come tomorrow, day after tomorrow.
Lordship.
Tomorrow, if I could come, I'll try and serve notice on the ROC again.
As none appears on behalf of the respondent authorities.
The affidavit of service here, Lordship, will keep on waiting.
Respondent in spite of service of notice. But this court find that one opportunity should be given according petition is informed to again inform the date to the respondents. This is the matter tomorrow under same heading.
Oblige you.
Affidavit be kept with the Yes.
Wait.
My application.
Yes.
Look, this is that matter. I'll quickly. Before that, on the last occasion, the Lordship had directed me to reserve the copy of the writ petition upon the learned ASG along with the judgments that are already shown. Now, this is a retrospective effect of that DRT transfer. Where I've served the learned ASG, Mr. Trivedi Mulad, including the judgments also, which I had placed reliance upon.
Yes.
Now, may I just, reiterate, and recapitulate whatever I placed, just
Who is appearing for the authority?
Mr. Trivedi was
The bank, Manoj, so it's
Yes.
Union of India has to reply.
Mr. Trivedi, in fact, was addressing your Lordship on the last day. We managed to get hold of him after several services. The Lordship had directed him to appear, on the last occasion. He appeared also.
Last occasion, Mr. Bhattacharya has appeared.
No, last occasion for the Union of
Gilwada.
India, Mr. Trivedi had appeared, He was physically present in court. He came and said that because there was a mismatch, the copy of the writ application was possibly not in his possession anymore. Somebody else was appearing. So Lordship had directed me to reserve again.
Nobody is there. ASJ office. The problem.
But the only limited issue is that your Lordship had in fact heard us. My Lord only wanted Mr. Trivedi to respond.
Yes. As informed. Password.
My Lord is passing it over.
Yes, next.
My lord, in item 12, my lord, I wish to appear on.
This is your matter, wherein my Lord had been pleased to pass an order directing the state to file a report as to whether there was a only display of an order above or below. This honorable court, they have disbursed the amount.
Where is the report of the district judge?
May I get a copy?
Who is appearing?
May I submit this?
You are appearing.
My copy, I think it is there with you also in the records.
Which report achi ki?
This is my own.
Not only subject to come sanction by my lord, but how money has been disbursed. I have got the money. So I have application in the my lord, along with an interest, my lord. Your lordship kindly consider this aspect of the issue. My petitioner before your lordship is a practicing advocate of this honorable High Court. He has been recommended by the department. You take to me. আজকে 4 তারিখ কি লিখেছে? প্রসিডিউর ডিলেটা হয়েছে so that has been resolved তারপরে ওই NSA 2 এই যে
Yes, you have been not instructed properly by your client. How many cost is to be imposed to you? Tell your client how much cost is to be imposed upon your client. Misleading you or misleading the court?
May I get the copy of the report? May I get the copy of the
Not
report?
necessary.
Unless I go through the
The
report.
judiciary draft. Your client had the knowledge that the demand draft which has been given, the name is not telling with your PAN card.
That is long, but no,
That's why. Then you have submitted the correct. Then you have not submitted the annexer 2. Then you submitted the annexer 2 subsequently.
the situation. The moment you lodge,
You have not. You whether you mention all these things in the writ petition.
that you got over, my lord.
Have you mentioned all the things? Please,
Admittedly, that has not been.
have you mentioned all the things in the writ
I
petition?
appreciate myself. All these things got resolved along that, my lord. Otherwise, my lord, after the order was passed by my lord, they have remitted the entire amount on Saturday. The order was on Thursday. Therefore, everything was ready. The mismatch in the
It was remitted your worship on 23/6/2026 only.
On 20th May 2026, you have rectified the PAN card, but you have not enclosed the annexer. Then the civil judge junior division informed about the so and so on 18th of June and 23rd June.
No communication has come from it. এটা খুন না, ব্যাংকটা খুন না। তখন থেকে বলছি ব্যাংক টু ব্যাংক। তারপরে সেকেন্ড
When the order was passed by the civil judge?
27 January 2026.
January
Immediately
26.
thereafter, I was called upon and
Correct. January 26, it was done. Correct.
yes, ma'am.
Then when you have had been to the office.
Admit thereafter, immediately I was called upon that there was a mistake in the PAN card.
When it was informed to you?
Immediately within 7 days, my lord.
When you submitted?
My lord, I have submitted my first representation on February 2000.
When you submitted your correct PAN card?
Prior to sending the, my lord, I cannot say the exact date, my lord, prior to sending the first representation that appears at page 48, my lord.
So you have submitted the PAN card on 20th February 2026. You have submitted the correct PAN card on 20th February 2026.
February. Thereafter, no communication from the concerned department.
No, when you approached, because after submitting the PAN card, you have not approached the authority.
Authority time and again meet, and the last annexure that appears at page 51. This is my reminder. By way of representation that was sent on 14th May 2026, my lord. This is what it happened.
What is the date of page 48?
Page 48, my lord. Page 48, my lord, it was sent through the speed post on 17th February 2026, page 50, my lord. It appears.
Then what has happened?
Nothing thereafter. Last.
Who is appearing for the district judge? You.
Yes, for the state, yes.
You take instruction whether the district judge has verified the report submitted to him. What the report submitted by the accountant he has submitted. He has personally inquired this, because before submitting before the High Court. Who is the district judge? You have a report.
I have this the detailed report.
Copy, yes, that's one. You have a report. Kindly come to the annexure A.
Yes, Your Lordship.
Correct. This is, I am returning here with the document sent by memo number so and so, so the payment order is passed in favor of so and so, but his name is not matching. So you are returning on February, 20th February 2026.
Yes, Your Lordship.
Correct.
Yes, yes.
Then you have enclosed, that is a regulation that's not required. Then you come to the page annexure C. 20th May. What about the 20th February to May?
Annexure C, Your Lordship?
Yes. With reference to your honor's letter, so and so, I am sending here with the corrected Xerox copy of the PAN card duly signed. So when he has submitted the PAN card? Annexure C, 20th May. The first communication was 20th February.
It's missing from my.
When you submitted the PAN card?
My lord, I am told
super the annexure A as my.
You submitted the PAN card on 20th May only.
So there is no such communication that you come and submit. I cannot say the exact date.
Communication. See, you are the advocate. And in the office in the High Court.
I do
The High
appreciate.
Court.
I
You have
do
to
appreciate.
go.
I personally, I am told.
The High Court, you have to go and receive the amount. The High Court will notice, or your advocate on record will go to the
Since the issue was getting delayed, I personally, the advocate, the writ petitioner personally visited the office. And therefrom it was told there is a mismatch of the PAN card, and immediately I corrected. I at the outset, my lord, I have said when in the month of February that I cannot give the exact date.
So you have
the communication of 20th, no communication to the petitioner, a single communication, whatever has been said in the report. No single communication has been made to the petitioner. Fundamental right to use footpath or any judgment.
The petitioner has filed the present date application, praying for a direction upon the respondents for release of the deposited amount of rupees 3,62,560 in terms of the order passed by the Learned Civil Judge Junior Division -1 Junior Division First Court, Paschim Midnapur, dated 20th January 2026. This court, by an order dated 20th July 2026, has called for the report from the district judge to explain as to why the amount has not been released in terms of the order dated 27th of January 20th January 2026. The district judge has submitted the report wherein it reveals that the amount has been released in favor of the petitioner. The petitioner has also accepted that the amount has been received during the pendency of the present date application. Yes, what is your claim further now? If you want to pay the interest, then you have to explain. Have you submitted all the documents, and I will grant in. But you have not disclosed when you submitted the annexure 2 and when you submitted the PAN card. You established that you submitted in February itself. Then I will initiate inquiry also, and I will pass an order for interest. Then counsel for the petition submitted. The petition has received the said amount, and he has not claiming any further amount or interest thereon. Accordingly, writ petition is disposed of. A report submitted by the district judge be kept within. If you have proved that you have submitted on February, then yes, next. Next.
I'm led by Mr. Formal team. I have told my team joins. Yeah. Well, we have served the copy of this for a supplementary opinion. I'm seeking your lordship's kindly file it contains photographs which would show the encroachment by the street vendors in violation of the act and the rules and the scheme. It has increased, it is completely blocking the pathway, causing fire hazard, causing loss to the loss of the space for the pedestrians to walk. This supplementary affidavit contains the photographs.
Who are you?
I am the writ petitioner. I am running a jewelry shop for the last 60 years in this place in Goriahat. And my shop frontage is completely encroached upon by the street vendors. I have made them parties also. Sorry, this
or this sorry, or this particular street vendors, or kindly, takes paragraph. I invite your lordship's kind attention, my lord, first to the an order passed in a PIA, my lord, by this honorable court, my lord, kindly takes 26 once.
Yes.
Lordship has got one order passed in WPOP 9/21.
Yes.
In my lord Akshay Kumar Sarangi, I had, my lord, filed an application, my lord, for being added as a party. My lord, that particular PIL. My lord, I have kindly, my lord, I'm placing the, my lord, paragraphs which are important. My lord, I'm placing, my lord, at page 26. This is an application for addition of party. Similar point has been raised by the petitioners with regard to implementation of the Street Vendors Protection of Livelihood Regulation of Street Vending Act 2014 and the West Bengal Urban Street Vendors Protection of Livelihood and Regulation of Street Vending Rules 2018 in various parts within the jurisdiction of Calcutta Municipal Corporation. Next page, my lord. It appears that the applicant, is my client now. The applicant has highlighted the inconvenience faced by the petitioner because of encroachment on footpath in front of their shops, and representations were made on 27th March 2023 and 30th June 2024 before the Kolkata Municipal Corporation and the local police station. We feel that issue may be separately decided in a separate proceeding, as it is confined only to the area in which the petitioner is carrying on its business. It would be open for the Kolkata Municipal Corporation and the local police station to consider the representations and act in accordance with law. Accordingly, IOGA 1 of 2025 stands allowed and disposed of. Well, this was the fate of my earlier application to being added as a party. Now, well, just for your lordship's kind appraisal, kindly also comes to page 28. And the order continues. One part I just want to highlight. Paragraph 8 at page 28. My lord has got it? Yes. He sees the court has, my lord, left with this direction. The authorities are directed to implement recommendation already within 4 weeks from date. Insofar as the area which is yet to be identified, the process of identification should be completed within a period of 8 weeks from date, and a comprehensive report shall be filed on the adjourned date. Well, that has not, my lord, happened as yet. But this was, my lord, the direction. Now, my lord, I was, my lord, given a leeway, my lord, to pursue my representations, which are part of this petition as well. My lord, separately to, my lord, for my enforcement of my rights. Now, my lord, kindly, have a look, my lord, at the act. I just place the photographs for your lordship's appraisal very quickly. Color photographs are there, my lord, at page Annexure B, which is at page 29. Color copy what happens is that slowly the vendors to take over the entire place. The law says, I'll come to that you cannot completely hijack the entire place. You have to restrict yourself, my lord. There is a question of my learned senior is here, my lord. If your lordship kindly grants the lead, my lord. The problem is that, Lord, the access, this gentleman, the petitioner, he runs a business, Lord. It's on the Guriahat Road. Lord, the access to his shop is totally closed because, Lord, the street vendors are sitting, Lord, in front. Lord, there is an act, a central act, and Lord, the state has made rules on that. Now, Lord, that act your lordships will find at page separately though. Lord, kindly first see the statement and object. Lord, the statement and objects, Lord.
Who is appearing for the authorities?
Lord, I appear on behalf
I'm for
of the
state, your lordship. He's for municipal authorities. I'm for state.
for the town vending committee. Lord, I appear. Lord, we have, in pursuance of the complaint made by the petitioner, not caused an inspection. Lord, the inspection, Lord, was attended by the stakeholders. Lord, everyone has signed. Lord, photographs will not have been taken. If my lord pleases, my lord, we can put this on affidavit.
So now what is the final?
Lord, the final is, my lord, that in terms of the rules, we are to ensure that 2/3 of the pavement,
correct,
my lord, is to be kept vacant. And the inquiry, my lord, was objected to this. Now,
was objected?
Oriented to this. So we have, my lord, done the inquiry. Where my lord pleases, my lord, we shall, my lord, put it on affidavit. My lord decides.
Inquiry and take steps and file report. If you made the inspection,
my lord.
So here the petitioner were the persons who are occupy the footpath. Then take appropriate step, vacate, take appropriate step and file the report. Nothing else. What remains?
But the statute, under the statute, they have not notified a rule, which is at page 32.
Yes.
If your lordships kindly, rather the scheme, sorry. The scheme, there's a rule and also a scheme. This scheme, if your lordships kindly not see, page 33, there's a definition of municipal vending committee.
Yes.
Municipal vending committee, that is, Lord, this is scheme, Lord, para 2, sub para 12. Then, Lord,
para page
33. It starts at 32. The scheme starts at 32. At 33, your lordships will find 12, municipal vending committee.
Yes.
It means town vending committee constituted under section 22 of the act.
Yes.
Then, Lord, please come turn the page. Kindly come to 25. Your lordships will find there is a definition of vending zone.
Yes.
Means an area or place of location designated as such by the municipality on the recommendation of respective municipal vending committee for the specific use by street vendors for street vending includes footpath, sidewalk, pavement, so and so. Now, your lordships will kindly see page 35. It also talks about issuance of license, para 4, and para 5, terms and conditions of license. And also, Lord, it is a complete scheme by itself, renewal of license, etc., relocation of urban street vendors, all this is here. Now, Lord, my main grievance is that, Lord, despite there being a rule, there being an act, and there being a scheme, this is not being followed. And my representation is at page 41, which I made to the municipal commissioner, saying that 2/3 of the footpath is to be kept vacant. And Lord, my customers, Lord, are not getting access to my shop. I can't myself get access to my shop.
Yes.
Rule 9 ta kothay ache?
Rule 9 ta.
Rule
36.
Kindly see the rules once. Kindly take rule 9, sub rule E. Rule 9, sub rule E. Rule 9, sub rule E. Kindly see list of vending zones along with their holding capacity to be prepared in consultation, etc. Kindly see Roman 1. 2/3 portion of the width of a footpath shall be earmarked so as to ensure smooth pedestrian movement. And 3, entrance and exit of any shop or house must not be blocked. This is exactly relief that I am claiming. And your lordships will see my prayers, Lord. This is also. And also rule 14.
Rule 14.5.
Rule 14.5, Lord, repeats, Lord, this.
Yes.
And Lord, prayer A, if your lordships find, I have talked about 2 representations, which are, Lord, at page 41 and 45, respectively. These are dated 27th March 2023 and 30th June 2024. These are the two representations which are at page 41 and 45.
Yes.
And Lord, I say that you remove this unauthorized encroachment on common passage and also, Lord, on the public footpath. This is, Lord, what my prayer is.
Yes.
Even my common passage, Lord, that there, Lord, there is an encroachment. So,
It is only increasing, sir. We have submitted the supplementary to show that it is only increasing.
right, when a law is made and the scheme is made, the rules are made, Lord, I am sure, Lord, the present municipal setup, they'll do something. I have come to court, Lord, with this hope. I just only leave it at that.
Yes.
Lord, I address my Lord on the merits of the case a little later. Kindly permit me to say that my learned senior friend is espousing the cause of a jewelry shop. Lord, his access, my learned friend's access to the shop is obstructed. But there are people on his right side who are the customers of the hawkers who are on the footpath.
Obviously, you are in the 1/3 of the footpath.
Now, my Lord, on the merits of the case, Lord, we are duty bound, my Lord, to comply. Lord, there are two things. If the hawkers, if the vendors, they spill over, my Lord, on the blacktop, which is the road, then, my Lord, they have to be evicted. If they encroach on more than 1/3 of the pavement, then they have to be removed. Again, they can't be found to be obstructing or impeding the entrance of, my Lord, any shop or any residence. These are, my Lord, the rules. We can't wish it away, we can't wash it away. The inspection was made even without intervention of the court because they made representation. So we, my Lord, would take action, my Lord, in accordance with law, considering their representation, and upon, my Lord, also, my Lord, hearing, my Lord, those who would be affected, and my learned friend would also be served upon with a notice. Upon conducting a hearing, we shall take steps in accordance with law.
I will record your submission and I will fix a date for to submitting the action taken report within 2 weeks or 3 weeks, whatever it is. How much time?
And let them come back, Lord, with a report.
That's why I am not disposing of
much.
I am recording the submission of the advocate and advocate. Let they file the report 4 weeks.
4 weeks, my Lord. I'm grateful. Deeply obliged. Lord, may I take my Lord's hand?
Yes. The grievance of the petitioner in the present date application that the petitioner has made a representation to the respondent number 3, 5 and 6, 27th of March 2023 and 30th March 2024, praying for taking immediate and appropriate action to remove the unauthorized encroachments on the common passage and the public footpath in front of the petitioner's business premises situated at 171 /1 capital A Raspberry Avenue, Gariad Road, Kolkata 700019. The Learned Counsel appearing for the municipal authorities. He was appearing for the municipal authorities. Learned Advocate appearing for the municipal authorities submit that the municipal authority already carried out the inspection and the process, and the municipal authority is taking appropriate steps. After giving an opportunity of hearing to the alleged encroachers as well as the petitioner, the municipal authority will pass appropriate order for eviction of the encroachment from the footpath. In view of the submission made by the council for the municipal corporation, the municipal corporation is directed to submit report with regard to this action taken by the authorities in terms on the representation submitted by the petitioner dated 27th of March 2023 and 30th January 2024 within 4 weeks from date. Let the matter appear on 8th of September 2024 under the same heading for submitting report by the municipal corporation. Come on 8th September.
Good. Kindly give us
it is made clear that both the parties are liberty to mention matter before this court either for early hearing or any further orders. affidavit of affidavit service ऊपर कर दे supplementary affidavit affidavit service and supplementary affidavit filed by the petition be kept with the
Just take some originals and because I don't 22 interim order is expiring today. I want 22. Interim order is expiring today, blood.
Why you are in this hurry?
Oh, sorry.
22. Record on. Which part of the respondent?
Respondent
Yes, is there. 22. You are appearing for item number 22?
Yes, sir. He's answering respondent.
Is that
in item 16 also I had some urgency.
just a minute? Yes, what is the submission?
Can you hear a matter today, sir? Sir, everything is over, sir. Only two things are decided. What he says.
Everything is over, but the court is not over. Court is not. I am keeping the, let the matter remain in the list. I will take the matter, no
Sir,
problem.
2.5 years, sir. 2.5 years. Simple point, sir. So the Supreme Court judgment, Justice Montgomery Bhattacharya's judgment that we have, in fact, sir, they are not allowed to be in the High Court, sir. They are supposed, they cannot be entertained in the High Court, sir.
Okay. Record an order. Though the matter is listed as item number 22 of the day's list, but the counsel for the petition pressed for, but the matter could not be taken of hearing for due to paucity of time. Counsel for the petition pressed for extension of time. The respondent number 4 appearing in person raised objection and submit that the matter is to be heard on merit as early as possible. Consider the submission made by the counsel for the parties. The interim order is extended till 7th of September 2026 or until further order, whichever is, let the matter remain in the list.
So can we do the hearing tomorrow, sir?
That's why I'm telling you, remain in the list. It will come tomorrow or day after tomorrow, whatever, I will take the matter. I am not disturbing the list.
Okay. So what I'm saying, just decide merit and close it, sir.
That's why. That's why I kept the matter in the list. I kept the matter in list. Whenever the time find, I will take the matter. No problem. Yes.
Tomorrow, I'll be great.
Yes. Next.
Mention.
And yes.
Lordship, this is a case of unilateral freezing of the bank account. Apropos your Lordship's last order, we have served the bank again.
So what you want?
Defreezing. Defreezing. For 2.5 years, bank account frozen. I'm squarely covered by your Lordship's decision in Zenixit Technologies, your Lordship. All I want is the bank account to be operational now. They have placed a negative lien of 6 lakh rupees.
Now, henceforth, I have decided I will not pass any order. I will keep all the order.
Your Lordship's order are becoming law, so we have to rely upon them. But Lordship is
16, na? Let come tomorrow. It will come tomorrow.
Let it
yes, it will be
right.
Madam, I am appearing we have Standard Chartered Bank. Madam, we have absolutely acted. Madam,
come tomorrow with the report. I will see to that.
Right. Only submission, your Lordship, may retain its position.
16.
Item 11, your Lordship was pleased to pass over on the ground of the learned ASG. I'll inform him today itself. One of the others are here.
Come tomorrow.
Only request for a similar request retain its position.
Tomorrow, come tomorrow.
I'm
Everything is covered by my judgment.
recorded with us. Recorded.
Which matter?
I
I will take, don't worry, I will take. Yes.
Item 20, today's list, sir, was selected for here in the first 10 matters by the last order. I did not mention, sir, because I thought that.
Item number?
Item 20. This is the fraud, forensic matter, is the first and I was.
Okay, but
I'm there for a small.
we'll take to that.
Wait, let it queue.
Finally, yeah.
Five of 2024. My lord had ordered on 1st April.
And my lord had told me that if I come to my lord had kindly fix the matter.
Yes.
Anytime as per your
It is not in the list.
It is running in the list. My lord.
Which matter?
Item number 54.
54, yes.
WTO 225 of 2000.
Ah. So what do you want?
If you could, my lord, put tax receipt on any day, anytime convenient.
Extra date दे दें September. 11 September 3 p.m. Yes.
সেট করাই আছে স্যার তিনটে
To examine both on commission.
This was called for your lordship previous also, but examination.
Item number?
Item number 121 of your lordship's monthly.
Monthly? There's no monthly list here only. This is the only list. I have only one list in the original site.
On Monday at item number 171, Monday was the monthly list of the original site. Yesterday it was item number 171.
$170. इतना मैटर है TS10 TS10 of 24
Yes. TS10.
कोई दे दो एविडेंस के लिए September 2 witness 2
The examination fee of the plaintiff's last witnesses to be concluded and thereafter the prosecutor.
on date 10th and 14th September at 3:45 record though the matter is listed of I think 170 of the days list, but due to procedure the matter could not be taken up for hearing, and counsel for the petition submit that this is the case of that evidence stage and the examination of plaintiff witness is going on. In view of the submission made by the counsel for the petitioner plaintiff, let the matter appear on 10th September and 12th September at 3:40, 14th September at 3:45 p.m. for evidence. Yes, next.
Item number 1 for that week.
Yes, I held the writ petition is maintainable, and second, I directed you to allow the petitioner to complete the verification of the document by by 7th. Today क्या date है? By 7th of August 2026, and after completion of the document, you process for the first is complete the first stage, then you go for the second stage.
Did I was praying for stay, man. It's formal stay.
Which we are opposing for.
My order is okay. Yes.
Also, I'm opposing the stay, man.
That it's record that I made for stay.
Land counsel for the letter, land counsel for the petitioner has prayed for the stay of the operation of the order.
No. Learned counsel, I'm for the petitioner. Mr. Bose.
London Bank prays for stay of the operation of the order.
I'm for the respondent number 3.
2, 3, 4. 2 and 3.
Only 3. Only 3.
Respondent number
3. Yes, ma'am.
3 prayed for a stay of the operation of the order. Land counsel for the petitioner raised objection. consider the submission made by the counsel for the respondent. The prayer is refused.
Very grateful to my.
Grateful for the patient hearing, Lordship. Yes.
This matter, my lord, answer.
Lord, I appear for the respondent numbers
Made my
3 to
submission,
7.
my lord, earlier.
Lord, 1 and 2 are not here, Lord. State.
My lord, last occasion also, my lord, I made my submission. Then, my lord, this, my lord, got, my lord,
Yes.
to be sick. My lord, it's a challenge, my lord, to a registration which they have obtained, my lord, under the West Bengal Apartment Ownership Act.
Yes.
My lord, there are certain, my lord, mandatory conditions, my lord, which have to be fulfilled before they can be, my lord, a registration. My lord, they are, my lord, some of the flat owners. I am also, my lord, a flat owner, my lord. I have, my lord, about what 4 flats, my lord, which is about 40% of, my lord, the area. There are some disputes, my lord. Admittedly, there is some dispute between us, my lord, with regard to maintenance. My lord, that doesn't mean, my lord, they can go ahead and, my lord, their civil suit, my lord, the civil court suits also which have been filed. But that doesn't mean, my lord, they can go ahead and, my lord, register under the West Bengal Apartment Ownership Act as well as a society. This is, my lord, really the issue. Not in there are some judges, my lord, which also, my lord, cover this issue.
What is a prayer?
My lord, prayer is, my lord, for cancellation, my lord, of the registration.
Registration of association.
Yes. Page 49, my lord, is the
Registration of the association. Yes.
now, my lord, this two things, my lord, are important.
So who are you? You are one of the
I am, my lord, also, my lord, some of the flat owners.
you are not the member.
I am not this association, my lord, registered under the West Bengal Apartment Ownership Act.
Okay.
There is also, my lord, another association which is there.
There are 2 associations.
Which is, my lord, who was carrying on the maintenance, and, my lord, there is some dispute between me and, my lord, them with regard to, my lord, the apartment itself.
One thing, before Mr. Banerjee proceeds, before he proceeds further, the state is a very important party here because the competent authority, they have their own affidavit, their stand is on record, it's with regard to limitation. But just like in the other matters that I was doing, their presence would be required. Because I am the majority of the owners, Mr. Banerjee's client is the minority. Out of 13,
Doesn't matter.
the
law requires.
That's another thing, but the competent authority probably should be here. Today they are not there.
I would have we started, my lord, made our submission before, my lord, on 8 December.
No, I'm not standing in the way.
15 January.
It's better to give a notice and have them come back on a certain day. Otherwise, it will be piecemeal. We'll be wasting your lordship's time.
It is, my lord, very good for Mr. Banerjee, my lord, to make this opposition because, my lord, he is the one, my lord, who's enjoying, my lord, the registration.
That's correct. That's correct. But who is appearing for the state?
State has its own affidavit. They've given a reply.
Yes, in fact, my lord, they did not. Everything is complete. My lord,
everything is complete. And
the stand is back, my lord, if next week I guess this
come back whenever.
The day is the problem.
Yes, I know. That's why, my lord, I didn't want to lose an opportunity.
Day is the problem. Otherwise, there is no problem.
September
No.
October.
Obviously, you will want next year also.
No, there's no special I have in this. Lord, this is now
registered. Let us understand, my lord, I am in. Because, my lord,
the state should be here. That's all.
Face of it, this registration, my lord, it could not have been done. Could not have been done because it had, my lord, some serious consequences, my lord, when you registered it, my lord, as, my lord, association, my lord, under the West Bengal Apartment.
This competent authority's affidavit speaks otherwise. My affidavit speaks otherwise. Petitioner, that will have to.
The petitioner is in support. The state is in your support or in support of the petitioner?
No, state is in the competent authority. Everything has been done in accordance with the act.
Affidavit states is all documents because, my lord, directed in the last order for documents to be disclosed. So all documents annexed. There's no documents annexed. How, my lord, this came about, and not only the state has issued a show cause notice to him now. Then also, my lord, after we filed the writ petition.
No.
Then, my lord, so in fact, state, my lord, should be there. I'm not saying, my lord, the state should be there.
So issue notice.
But then, my lord, may I, my lord, request for this? Only this, my lord. If, my lord, it's possible, my lord, 3 o'clock, any day, my lord, next week, week after that. But, my lord, I just want, my lord.
The first date available, kya hai?
That will not help Mr. Shuddha Sattva Banerjee, my lord.
No.
So that's
when somebody's calendar is as busy
8
as yours.
September, you'll get the date. 1 month after.
the difficulty would be, my lord, even if I wait till 8 September, again, my lord, the
If
state.
today also, if you argue the matter, but the state is not
Not there. It should be piecemeal. I'm supporting you, Mr. Rahul.
Obviously, we will.
Always.
Again, my lord, if the state is not there, my lord, will suffer the same.
I will. That's why I will specific
directed
order
to-
I am passing here.
Second.
Second, sir.
The none appears on behalf of the state, but this court find that the presence of the state is necessary. Accordingly, for the interest of justice, the case is adjourned. The petition is directed to inform the next date of hearing to the office of the government pleader. It is made clear that in spite of receipt of the notice of the hearing, notice of next date of hearing, comma, if none appears on behalf of the state, comma, the matter will be taken up for hearing in the absence of the state. Let the matter appear on 2nd September at 3rd September at 3:45 p.m.
No, I also don't want the state to be here with that affidavit.
Again. Closure of the bank account by? By bank of India. Yes. Why? On the basis of the competition by a third party. The third party in this case, my lord, is a former director of the petitioner company. My lord, would kindly take the master data first, which is at page 20 of the petition. Yes. That would show the present position, my lord, for the directors of the petition. Company. Yes. At page 21, my lord, Gulshan Kumar Gulati, that is the petitioner number 2, and Rishi Gulati, that is the son of the petitioner number 2. These details are there with the bank. So what happened? Me, my lord, on the 14th of May, I submitted a bank draft for around 50 lakh rupees. On the 15th of May, to the bank. When you submitted the bank draft? My lord, I am told sometime on the 14th of May. 14th of May 2026. On the 15th, my lord, when I go to the bank, I am informed that my account has been frozen. 15 May. 15th of May 2026, when I go to the bank, my lord, I am informed that the bank account is closed or frozen and all banking activities have been suspended on the basis of a complaint by a third party. I am not, the bank does not provide the letter or the complaint letter, but it just shows me a document. Later on, I come in possession of that document by way of WhatsApp. That is also annexed. That is P2 at page 22. Yes. Kindly takes page 22, subject, formal instruction to halt encashment of demand draft in the name of Lloyd Logic Systems Private Limited, account number such and such. Now, this, my lord, is printed on a letterhead which bears the name of the petition, but it is not from me. In fact, this document does not even have any signature. Lloyd Logic System, who is the? My lord, that is the petitioner number 1 company. I am the director of the petitioner number 1, that is the petitioner number 2. Now, this document has not been issued by me. On the 15th itself, I write a letter to the bank man. That is at P3. That is P3 at page 20. Who wrote this letter? My lord, the letter which is at page 20. Authorized signatory. My lord, it does not bear a signature. I am told, or I was told by the bank, that this letter has been sent by the brother of the petitioner number 2, which is former director of the petitioner number 1. Be that as it may, my lord, at the present moment, it is
a unilateral closure of my bank account on the basis of a complaint by a third party.
Yes.
This person is not a member of or not a director of the petitioner number one, not this communication. Page 24, my lord, my first demand for justice on the 16th of May itself.
Yes.
After instruction regarding unauthorized letter, account number such and such, demand draft number such and such. Thereafter, my lord, two more demand for justices are there. I will place the latest demand for justice, which is at page 29, dated 4th of June 2026. Is addressed to the branch manager, Union Bank of India, Calcutta.
Yes.
Reference the current account number is mentioned, my lord. The name of the petitioner is mentioned. Subject is urgent request for restoration of account operations. Salary is outstanding, 13 days without response.
Yes.
Now I give two alternative propositions. I say that either the closure of the seizure is illegal to resume the operations, or for the meantime, let me operate my bank account to the extent that I take out the money which is required for my salary and to create my salary. I receive a response which is at page 32 from the bank. It's kindly take 10th of June 2026, Union Bank of India, addressed to the petitioner number one. The bank says, with reference to the above, we have received the legal opinion, that is their internal legal opinion, with regards to your account status from our panel learned advocates. And the opinion as under. They give me three options. Option A, production of an explicit interim order or direction from the Honorable NCLT, where the case is being filed, instructing how the account should be operated. There are no proceedings pending before the NCLT. No case has been filed before the NCLT to my knowledge. I have already brought that to the knowledge of the bank. Second option is joint unconditional written instructions signed by both disputing groups for specific necessary payments. And the third option is a fresh undisputed board resolution, past resolution after the judicial resolution of the director appointment. These are the options given by the bank. Being active covered by decisions of my lord as well as of the coordinate bench, saying that this type of action where the bank account has been under the banking of operations have been frozen on the basis of a complaint by a third party is not for.
Yes, sir.
My lord permits, I can place those questions.
My lord, first of all, my lord, the third party is the brother. It is a family company. And the director, my lord Gulshan Kumar Gulati, he was a director and he resigned on 2017. He is still a shareholder of the company. It is a dispute in between the family members.
Who is the signatory of the account?
Yes, my lord, that we have, that bank has asked for, because there was a letter from the learned advocate, my lord, asking the branch manager that there is no resolution of the board since 2007. My meeting was held from 2007 and no blood audited report has been filed. And
that is correct. That is correct.
So, this option was also, and there is a case filed before the NCLT. But if your verses kindly see, but there is a bunch of letter. Yes. Yes. একটা কপি কোথায় গেল সব আলাদা করে দিস না কেন ফার্স্ট পেজটা কোথায় গেল
Where is the order of the NCLT?
Sorry. Yeah.
Hey, Manutas, it's a pin code. इसको निकाल के ठीक से pin हाथ में लगे.
May I separated this kind of within একটু আমার দিন
Yes.
My lord, if your lordships kindly see the first page of that letter,
Yes.
my lord, the subject matter. Legal notice on behalf of the Jagdish Kumar Gulati shareholders, beneficiaries, owner, and erstwhile director of the Messrs. Lloyd Logistics System Private Limited, calling upon Union Bank of India to maintain the existing operational restriction debit fees on the company's bank account maintained at your branch in view of the wrongful, clandestine, and procedural defective appointment of Sri Rishi Gulati. They are the brothers, my lord. Rishi Gulati and
You saw the notice.
yeah,
But
as
private
the-
respondent, you have not made a party. Yes.
not this, not like that. My lord,
Yes, yes, continue.
Yes, my lord, kindly see. Then, my lord, as director on 13th March 2026, the suspect resignation of erstwhile professional director Sri Girindra Biswas impeding proceedings under section 241 to 242 of the Companies Act 2013 before the Honorable NCLT Company Law Tribunal, New Delhi bench, and the bank having already received actual notice through two prior written communication dated 15th May 2026 and 20th May 2026 and a personal meeting on 20th May 2026. Notice under the Companies Act 2013, the Banking Regulations Act applicable RBI guideline and all other applications law. Then, my lord, this is the entire letter. Lord, I am not troubling this. I am just showing this. Yes, my lord, kindly see the page 4 of this letter. Page 3, my lord, the paragraph clause 6, shareholding pattern of Mrs. Rishi Creation Private Limited.
That is correct. Whether he has obtained any order from the court restraining the bank for
No, that is the, my lord, immediately, my lord, and there was no particular meeting.
Maybe.
2007.
Maybe.
If you see, yes.
Okay, what, sir? Please bear with me. Okay, you have received the complaint. Correct. There is no order. He is running. There is no dispute that he is running the account.
No, my lord, what I am asked for, the bank asked for that you show me the resolution of the board of the directors who is the person to the account. That won't apply. Three options. And see, bank has given three options. That please provide because amount for the bankrupt and huge amount. So
first of all, that is huge amount once you have stopped the account.
Yes, my lord, and I have asked
stopping the account.
Yes.
Who was running the account?
But the
account in your bank.
Yes.
Whether the person who made a complaint, he was the signatory of the account. Whether he was the signatory of the account.
But it is an admitted fact that he was the director of this company.
He was the signatory.
He is a shareholder.
And in that case, I will pass an order.
No,
there is no court is required. The bank is taking all the recourse to decide whether who is the shareholder, who is the entitled to having the bank account, who is all the things.
No.
If you do, if bank is doing like the court will be closed tomorrow.
What I am asked for, three options I am asked for.
I am asking you.
Yes,
you tell me because this is only after you block the account. This page number 32 is only after you block the account.
Yes.
It is not running account you ask for to submit the document. It is not your case.
Yes.
If it is your case, yes, he was running the account and you got some suspicious over the operating the bank account. You ask for some document. He has not given the document and you have freeze the account. You have blocked the account. But here the case is that you received a third party complaint or shareholders complaint. You stopped the account. He made a request. On the request, then you ask for the legal opinion. On the basis of the legal opinion, you are sending, show me the law in the bank who is not the signatory, who is not the beneficiary of the account, can give a report and without the investigating agency or without any proper investigation, you can, and without the order of the court, you can block the account. Show me.
My lord, kindly keep this matter tomorrow. I shall take instruction, my lord, from the bank because my lord, the bank has immediately when the initially bank has my lord, freeze the account, it is admitted. No doubt about it. And immediately thereafter, he has asked for bank asked for that. Kindly give me this.
So I'm asking.
Yes.
See, you are acting upon a third party representation. Correct. You are acting upon a third party representation because he is not the account holder. He is not the signatory of the account. If today I will write a letter, so you block the account, you will block the account.
That is the reason I am not connected. No, that is the reason for which bank asks for that. That who is the executive?
Who you ask?
Because the 17
is so whom you will ask? Who will make the complaint or against whom the complaint?
Some concern raise the complaint. Ask for bank. Ask them. Ask the executive director. So ask because they are
passing an order. You are not understanding the question. You are putting the question to the court. I am again and again asking if you receive the complaint from a third party. Instead of asking the details from the third party, you are asking the details from the account holder that after blocking the account. And you are relying upon the opinion of the advocate. Where is the banking rule? Where is the banking rule? Your manager is not having the rule. Now you are acted upon the legal opinion. This can be acted as a legal opinion or on the basis of the rules and regulation of the
that is absolutely correct. But the bank's impaired judgments are
your manager who has done this, I will send the name to the he has to be suspended.
There was written by an advocate making certain allegations.
With the report, you come tomorrow with the law whether on the third party instruction you can block the account.
Very well,
I know. You know the latest SOP.
Yes.
The SOP has come in January 2026, which has been implemented in April 2026. You know. How many pages the SOP is there? Your bank is not going with the SOP, bank is not following the RBI guidelines, and you acted upon the legal opinion. Ask the legal opinion and asking for the person. First, you have to see the interest of the person who made a complaint. First, you have to ask. Your own. Yes, he is the shareholder. That's why you produce the minutes of the meeting. He is the signatory of the bank. You are dealing with your client like this.
No, Malad, kindly see the person concerned is going to complain.
And then you block the account. No.
Because
the counsel appearing for the bank failed to satisfied with this before this court how the bank has blocked the account of the petitioner only on the receipt of the third party complaint. Let the bank address the issue tomorrow. This is the matter tomorrow on the same heading.
Or instead of tomorrow, can it be day after tomorrow?
Day after tomorrow.
Very well.
Yes.
Vajapia for the respondent. May it please your lordship, my lord. This is that MSME matter which Mr. Abhijit Mitra was arguing before your lordship. My lord, on the last occasion, we had submitted our learned
What
friends
is the stage of the surface?
My lord, 13.2 issued, 13.4 issued, but before separate section 17 going on, separate other proceedings.
17 is going on.
17 is going on. Section 13.4 done.
Possession?
Representation before possession not taken, only possession that has been given, but no steps have been taken for actual physical possession.
When you made the first representation on for the revival scheme?
My lord, I'll just tell your lordship.
Have you
Lord,
made any
kindly-
presentation for the revival scheme?
Yes, my lord.
When?
From day one, we've been saying that.
When? Show me.
My lord, kindly takes.
When the 32 notice was
When
NPA, when the NPA?
NPA is 29th December 2023.
29 December
2023.
2023. NPA.
The 13th notice
13 notice
is valid 21st March 2024.
21st March.
Yes, my lord. Page 156.
21st March 24.
24.
Yes. Page
156, volume 2.
Yes. Then you given the reply. When you given the reply?
I have given the reply on 17th 2024.
17 May 2024 reply.
In 3 places, 17th 2024, 167.
Yes.
Volume 2.
Have you taken the plea of the revival scheme?
3 times I have said that I am an MSME. I need to be declared as SMA 01.
Number 167 and
167, just 170, 180 and 182. It's a rather long letter. The to the 13.3 my reply bank has replied to that saying none of that is required.
Where is that?
That is regarded 27th of 2000. Specifically about interest, saying that this compliance is not required. 13.4 is issued on 16th September 2024, which is at page 107. 16th September 2024 is a 13.2 notice.
Yes.
13.4 notice, I'm sorry. Don't seeing that the bank had no interest in following the guidelines, we offered several proposals. Everyone made the point. Especially
Okay, show me the where you have taken the plea of the revival scheme.
Kindly come to page 211.
No. Your 13.2 reply is.
I'm so sorry, my lord.
167.
156 is the 13.2.
157.
167. Volume 2.
Well, which paragraph?
That comes to paragraph 8 at 172. My lord, one thing I must point out to your lordship, this loan that was availed by the petitioner was availed from the SME branch of the State Bank of India, small medium enterprise branch. Paragraph 18, if I may say, your lordship, subsequent to the financial demands to facilitate us irregularities. It is, I emphasize this, my lord, to emphasize that I did not receive regarding the utilization they were classified special mention accounts. This your lordship has seen hundreds of times SMA 012 as MP Reserve Bank of India. Well, at first instance. Second instance, 40 at page 180. Back. Page 180, 40. Of established by the Reserve Bank of India, ostensibly designed for the mutual benefit of the customer's interests. Lastly, paragraph 50, page 182. Your lordship has that, Miller?
Yes.
It was declared by the declaration of the status and received a comprehensive statement of accounts from the state office. A situation which has persisted fully. So there are 3 instances in May 2024.
Where is your request to the bank to give the benefit of the revival?
Well, if I may allow the allowed by connectivity is very poor, but then if your lordship kindly allows me, my lord, here, lordship, there are 3 requests by us, not in so many words saying that MSME benefit, but we make 3 times we make settlement proposals on MSME ground. Lordship kindly takes firstly the proposal made by us on or should kindly page 209. Page 209 on 4th December 2024.
Yes.
4th December 2024, Lordship, page 209. Should we make a proposal? One-time settlement, Lordship kindly comes to paragraph 8, and Lordship kindly can see paragraph 11 first. Paragraph 11 at page 210. After all, this is a layperson writing. We hope the bank shall extend a hand of cooperation to this MSME and SIC unit for a reasonable and amicable settlement. Or should we write this, and they are under an obligation under the MSME regulation to immediately then refer this to the MSME Council.
Where you are mentioned, MSME Council refer to the
paragraph 11, page 210, paragraph 11.
An amicable settlement of the work. That is a one-time scheme. That you ask for the work.
For settlement, we ask 210, paragraph 11, hand of cooperation. It's a proposal we made. So Lordship, this. Then we make another revised proposal, Lordship, page 211. Page 211.
Yes.
We again say at page 213, bottom 13 and page 214, paragraph 15.
Yes.
Kindly see this in conjunction with the MSME circular.
Which paragraph you are reading, Mr. Mitra?
Page 214, paragraph 15.
Yes.
We hope that the bank shall extend the hand of cooperation to this MSME and SIC unit for a reasonable and amicable settlement. And now, if this kind of a proposal is given to a bank, Lordship kindly sees what is the requirement under the MSME circular. Lordship takes a look at the MSME circular kindly. MSME circular.
Page 110, sir.
2016. If you can give the page number, Mr. Tolkar.
Paragraph 1. Annexure P8.
Yes.
Lordship, kindly come to paragraph 4.1.
Yes.
Any lender that is on identifying an MSME or suit as SMA2 or suitable for consideration under the framework, or on receipt of an application from the stressed enterprise, shall forward the cases having aggregate loan amounts above 10 lakhs to the committee for immediate convening of meeting. But I am on that. Convening of meeting and deciding on a corrective action plan. So they should have then not just, we are writing again and again, not in very precise words. At that time, lawyers were not approached. So we wrote them, help us. We are an MSME, we have not yet sunk, but then we are on the verge of sinking. So when we write this, they should have then send our case to the committee.
Yes.
Well, this is all I can put my case to, my lord. Proposals made, and thereafter, but they sat over it. Whichever form we made a proposal, what they should have done is a corrective action plan. They should have explored. By paragraph 4.2, kindly see paragraph 4.2 of the notification. where an application is filed by a bank lender and admitted by the committee shall notify the concerned party about such application within 5 working days and require the enterprise response so and so, so and so. The Lordship, most importantly, Lordship kindly comes to paragraph 5.3. The options under the corrective action plan by the committee may include rectification A, B, restructuring, next page, and C, I am on C, recovery. Once the first two options at A and B above are seen as not feasible, due recovery process may be resorted to. So when we make this, so the intention behind it, you first explore the settlement option. Firstly, my submission has been all throughout that they should have done it at the very outset when we turned SMA 2. At that point, this should have been done. When we turned SMA 2, they did not do it. Thereafter, when we wrote to them also, they did not follow the procedure under 4.1, and now they cannot say that since I have issued the 13.4 notice, your remedy is gone. Your remedy is gone. Lordship, that is like, and Lordship has seen, well, I had shown my law's judgment in the case of doers. Can you just hand up the doers judgment once more, Mr. Torupdar? The doers judgment.
Yes.
And when it is modified at the final hearing, what does the division bench do when we go up in appeal? Kindly see my lord's doers judgment. That is still stand the
not filed, appeal not filed.
Yes, but thereafter, at the final hearing, the order was modified by Justice Ray, by Justice Aniruddha Ray. Lordship, please hand up the copy of the order of Justice Ray.
That was the division bench order, my lord. This is my lord.
Final order first you give, and thereafter I shall show the division bench order. Justice Ray then put conditions. Did not really alter, did not really give the change, but change substance of the order. Lordship, kindly come to paragraph 54. Made it conditional. We went up in appeal from Justice Ray's order.
Yes.
And the division bench, because in the meantime we had approached the DRT, and there was a DRT stay already granted.
Yes.
Lordship kindly comes to the second page of the order, the fourth line, the third or fourth paragraph. It is clarified that the parties are at liberty to raise their respective contention in appropriate form according with law, because this was our prayer to withdraw. Death Recovery Tribunal will not be influenced by any of the observations made by the learned trial judge in the impugned judgment and order. So in other words, it is like the division, so I could rely, so that I could rely on my lord's order. Because the division bench said that without being influenced by the order under challenge. And as a result of which, the stay, which was granted by the DRT, is still continuing. So, Lordship, and Lordship, in these facts, Lordship only considers also the Bridza judgment of my lord, the Bridza judgment. Since here also we had approached the bank at the very threshold for the MSME. Lordship kindly takes the Bridza judgment, what your Lordship, in fact, my learned friend also wanted to rely upon that judgment. bridge judgment, Lordship. I don't have it here.
Yes, part of the liquid text file.
If you can just give it, I can't somehow find it just now, Mr. Just place it, please.
Paragraph 25, my lord.
Just place it. Yes, Lordship, yes. Well, I have got it, well. Paragraph 24, I must show at the beginning to show that our case is not that clear. We did not point out the notification. Express 24, I must point out the flaw and what is not there in my case. Court finds the petitioner's reply on 13th August informed the bank is valid. Our client hadn't come to a law, but now we're considering the case in terms of MSME. When the bank came to know about the Lordship kindly sees paragraph 25. It is mandatory on the part of the bank, paragraph 25. It is mandatory on the part of the bank that in reply, if the borrower claims the benefit of the framework with reasons and affidavit. Well, affidavit, Lordship, I had shown that is under 2015 notification. That's for 50 crores plus. 50 crores plus cases, that affidavit is required, and that is the 2015 notification. While for 2016, they called out a different regime. That is the 2016. 2016, there is no scope for filing affidavit. But none the same, we are willing to give an affidavit. Let them at least consider, because after all, from 2024, we have been trying. So, my lord, I leave it to my lord. I can't. And Mr. Torabdar, if I have missed out anything, please indicate. Please indicate.
One thing, sir, with your permission.
Please do.
Page 215. 30th March 2025. My last letter, 215, at paragraph 12 and 13, which is page 217, where I specifically take the point of pronates and paragraph 12 and 13, I say that you've not followed. Even after that, I write to RBI saying 2016.
When you given this letter?
30th March 2025. Paragraph 12 and 13. And my lord, then my lord, even in the month of April, we've written to the RBI saying that 2015 and 16 circular, page 219, my lord, at paragraph 6 and 7.
Yes.
Lord, with regard to the judgments that has been cited today, my lord, I need to consider those judgments. Lord, firstly, my lord.
No, you only satisfy this court. Okay, whatever the action you take. Once you received the request of the petitioner with regard to the benefit of the revival of benefit of the scheme, so why the bank has not
Whether, my lord, subject to my lord's concession, my lord kindly takes the letters that has been showed by your lordship today. Starts at page 167 onwards. Let my learned friend show, my learned senior friend show that a single line that he wants a restructuring under the MSME scheme. No, rather he is accepting the NPA debt, the NPA amount, and is offering for a one-time settlement.
Correct.
Now, if your lordship takes page 167, that is the first letter after the issuance of 32 notice.
Yes.
Note here he writes representation against, if your lordship takes 167.
Yes, I am there.
Representation notice against the purported notice under section 13.
No, they are referring paragraph 18.
Lordship, paragraph
page
18.
172.
Lordship, page 172. Lord, he does not say that I want to pay in terms of the, if your lordship takes page paragraph 18. Subsequent to the aforesaid events, the bank, despite being urged to facilitate us in regularizing the business and restoring the tea garden to a suitable and operational state, following the unrest, declared the loan accounts for the credit facility of non-performing asset on such and such on grounds of purported irregularities. It is imperative to emphasize that I did not receive any prior reminders regarding the regularization of the loan accounts before they were classified under the SMA category. Reserve Bank of India guidelines and separate judgments, it is not required. As designated as a non-performing asset as mandated by the Reserve Bank of India. The bank thereby imposed onus of us recovering a substantial amount of rupees such and such only from us as communicated through your legal counsel in a later date such and such. But he is admitting this. He does not ask for the scheme for the MSME scheme. If your lordship takes the last penultimate paragraph of this letter, my lord, that is a page. What does he say? Does he say anything about, if your lordship takes page 60, the 186 onwards, the 185 onwards, paragraph 63. The asset under mortgage involves several thousand workers and families, and their action on repercussions has to be taken, keeping them in mind their welfare.
There's
nothing. But however, in spite of all effort, paragraph 65, however, in spite of all above, the bank shall work out a plan and program for the revival of the unit as advised under related date such and such, shall discuss the same with the bank, being one of the key stakeholders, so the business can be revived and payments of the dues of the creditors can be made. However, for this exercise to be designated, implemented, results to be seen.
But then what about the 217?
270, lordship.
217.
217. But all this is his restructuring proposal, nothing more.
217.
Look, 217, my lord, if your lordship takes paragraph 13.
12 and 13.
12, 13. In the already, please also consider this letter as a formal request in terms of the framework revival. Look, this is the letter. Kindly takes the date of this letter. When was this letter issued? In March 2025.
Yes.
After everything had happened, the police judgment and your lordship judgment says.
When the section 13 notice issued?
Kindly give me a moment. 13.2 was issued on 21st March 24.
Correct.
Thereafter, 13.2 was issued. 13.3 he gave the reply. In the reply, he should have given this point. He should have taken this point. After waiting for a month, he stood up and said that I want a revival scheme under MSME.
Yes.
There are a series of correspondence, not a single response.
What is the stage now?
13.4 we have issued. He has challenged the proceeding before DRT. DRT, the final adjudication is.
So you do one thing. You do one thing. So now what is the stage? You have taken possession?
Yes, symbolic.
Symbolic you have taken. I am not going on that. Correct. They may file an application. You considered it. If your bank is finding that he is entitled to get the benefit of the revival scheme, you considered it. You not consider, then you.
The difficulty is, garden is still running. Garden is still running. He is getting the cash, but does not deposit and the money in the bank.
Correct.
But he will have to deposit the money in the bank. If he wants to get the flow of the amount account, he has to pay the deposit.
Take that in your revival package. Consider
the revival package has to be submission. Stage it is not possible.
Why?
Because everything after all the things are flowed down. If your lordship takes a lordship judgment once.
When that's I appreciate. But 30th March, when you taken the symbolic possession.
13.4 was issued 16.924. Almost a year.
When the symbolic possession was
16.924. 16.924.
September 20.
Lordship. Almost 2 years, my lord.
2 years they have not taken physical possession, they are not sold.
Yes,
so what has for 2 years it is lying as it is. So lordship, considering that, lordship, give us let them consider if it's a running tea garden.
2015 and 2016 circulars of the Reserve Bank of India March 2017 circular. That will check the circular 2017. I do not know what is there.
Again, with my learned senior friends, leave my lord, only the master direction in 2016 circular is made 2015, then March 2016. That has been incorporated in the master direction of 21st July 2016.
And now
those two circulars have to be followed. It's not 2017 circular, my lord.
That's correct. That's correct. But you have not made the representation earlier. After the possession, you made the representation in March 2025. That is the only difficulty.
Even NCLT proceedings pending. He takes time there. He does not allow us to make any progress there.
You have given, but you are not asked whatever the you have pointed out this code, but in any of the document, you are not only the 30th March, you elaborated the paragraph 13 and 14. But prior to that, you're not. And by that time, the already possession is taken. Then what?
If your lordship takes only one page at page 56.
Possession not yet taken, actually, but that's not, you kindly draw the distinction between possession, symbolic and actuals.
It is a sanction letter. But he says he does not have the MSME. He has been benefited with the GECL and FRTL. The GECL is a COVID at the time of Supreme Court granted them the COVID circular, and we have been enjoying this facility. The GECL, if a lordship takes guaranteed emergency credit fund or order. He took that loan. It was an additional above whatever it was without any security. So now if there are bank that will not deposit the security, there is no security as such compared to the outstanding dues.
With my
your lordship knows what is the present status of the guardians, but I do not have to emphasize on that, my lord.
Yes. In that case, Mr. Torabda, can you just show the division bench judgment in SRC Steel, where this Sarfezi and this MSME has been analyzed and considered? SRC Steel.
Yes, sir.
That I will take.
Well, I will be relying upon the prominent judgment. That is if your lordship in many judgments your lordship has dealt with paragraph 10, 20, 21 and 22.
Okay.
But
this matter is there.
I understand, Lord. Lord, only Lord, in that case, Lord, may I come back
tomorrow?
Lordship.
Record and all. Counsel for the parties have argued the matter length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow under the same.
Tomorrow, my lord. Grateful. Tomorrow. Great.
Delving into the 345 matter, Lord, there is a consent of item number 6 that octogenarian and Lady Mallet. But the public premises act, they have taken the possession of the premises, but all the belongings of my client, my lord, remains inside, my lord. So, my lord, my learned friend, in his usual fairness, has seen, my lord, that on behalf of the LIC, my lord, that they have no objection if we can take.
Let me see. I will see. Let the first fixed matter come. I will see.
We will wait. My lord, we will wait.
My lord, this is my petition. My lord, this is regarding proceedings under the Estates and Acquisitions Act, my lord, initiated against a property at Club Street. Lordship may recall, my lord, here I say that I am the beneficiary under a will by which, my lord, this property has been left to me, but, my lord, by the orders impugned in this writ petition, my lord, it is said to have vested in the state by process of escheat. My lord will kindly see the orders impugned, page 302 and 304 of the petition. My lord, lordship has previously had the occasion to hear this matter. Lordship may recall, my lord, orders have been passed, my lord. I'll just try to refresh my lord's memory. Here, my lord, we had also filed an application for grant of letters of administration in respect of the estate of the stater who granted the will. My mother was the executrix of the will. She has, my lord, really withdrawn. And my lord recused herself, saying she will not act as executrix. ALA had been filed, withdrawn subsequently. Today, we filed an application for grant of letters of administration to me in respect of this estate. Then, my lord, at that juncture, the question of escheat came. While I'm fighting for grant of letters of administration to me, the state comes and says the equity has vested in me. So, in the probate proceeding, my lord, there is an order of the probate court adjourning the probate proceedings pending the outcome in this writ petition. So, in these circumstances, my lord was pleased to pass an order dated 16 December 2025, my lord, calling upon the respondent to take instruction on whether, my lord, the writ petition can really be kept in abeyance until the probate proceeding is disposed of. Because, my lord, the Escheats and Forfeitures Act says the proceeding under escheat must have a calculable interest or an interest sufficient to maintain an application for grant of administration. So, my lord, that will be determined by the probate court or the my lord court entertaining my application for grant of letters of administration. So, in these circumstances, lordship had called upon the respondent to take instruction.
Why you have filed the writ petition?
To challenge the escheat forfeiture proceeding, because the state says the property is vested in them.
Which order?
My lord, the orders impugned, page 302 and 304. If my lord will kindly see volume 2, page 302. 26 December 2018 order, my lord, page 304. Yes, my lord. If my lord will kindly have from page 301 at that's annexure P3, volume 2, P23.
Subsection 3 of section 4 of West Bengal.
Yes, so they gave a notice, my lord. If I may place this, 19 November 2018, under subsection 3 of section 4 of the West Bengal Escheats and Forfeitures Act, read with rule 3 of the West Bengal Escheat and Forfeitures Rule 2017, whereas competent authority in respect of premises number 14 Kid Street, Kolkata 16, under Escheats and Forfeitures Act, has reason to believe, on receipt of report from reliable sources, that there is no legal owner to premises number 14 Kate Street, Kolkata 16. And whereas the competent authority is satisfied that the provision of the West Bengal Escheats and Forfeitures Act 2012 are applicable in respect of premises number 14 Kate Street, Kolkata 16, and therefore desires to cause an inquiry as to whether the facts as stated in clause G of section 2, as would attract operation of section 3 of the Act, exist in respect of premises number 16 Kate Street, Kolkata 16. Now, therefore, notice is hereby given to the effect that if any person has any claim, right, title, interest whatsoever over the premises number 14 Kate Street, Kolkata, he may present his case before the competent authority and appear for hearing, etc. Then, my lord, the next document is page 24. This is impugned in the petition, 26 December 2018. This is an order, my lord, made under section.
As per your case, the land belongs to whom?
To me, my lord. I am the beneficiary under the
beneficiary. Original owner. Who was the original?
Yes, my lord. There is, I'll just give your lordship the family tree, my lord. There's
premises number 14.
Yes, my lord.
KYD Street.
Yes, my lord. There, Armenian Christian family. There is a Kachik John Avatun. Is Emily Avatun. Daughter is Annette Ann Akkar. Daughter is Annette Mary Emily Akkar. She was the owner. She is the testator who has left a registered will in favor of my client. And my client's mother was the executrix of the will.
So the original, what is the relation with you and the original?
No relation, my lord. I have shown your lordship the will. If I may invite your lordship's kind attention to the will once again. Lordship will find that, my lord, at page 27, volume 1. Kindly see this, my lord. This is the last will and testament of Miss Annette Mary Emily Appkar, daughter-in of Gagarin Johannes Appkar, about
2013.
2013. If your lordship will kindly turn the page, my lord. Page 2, second paragraph. It says that they are the owners. Kindly see the last, my lord.
So,
lines of paragraph 2.
Till date, when you have paid the municipal tax and all the revenue tax not paid.
No, my lord, municipal taxes have not been paid by me. But, my lord, possession is admitted. Because
you are in possession?
Yes, my lord.
No, my lord, we are not admitting.
You are
Since 2018, the government has taken possession. The property having vested in the government, my lord.
May I inform your lordship, my lord, that in the probate case, I had filed a contempt application saying that while I'm in possession, the state authorities have come, broken open the lock, and started doing some work at the premises. At that juncture, the probate court granted an order of status quo. So I say I am in possession. And it is disputed that they are in possession or not, but my lord, that is the case. And my lord, what is my relationship, my lord asked? My lord, we are the servants of this Annette Mary Emily Appkar. Here, my lord, each two paragraph 2 of the will records, my lord, my mother, last 5 lines of paragraph 2, my lord, page 2 of the will. Turning page 29.
Yes.
Kindly see last paragraph. I treated Muhammad Abdul Khan as. Yes, my second paragraph at page 2, may I place? My father, Gagarin Johannes Appkar, died in 82. My mother, Annette Appkar, died in 86. After the demise of my parents, I am living at premises number 14, Dr. Ishaq Road. After the demise of my mother, Annie Appkar, I have asked Muhammad Abdul Khan and his family. That is, Abdul Khan is my father, and his family, which comprises of Nagman Praveen, my mother, and his son, Mubashir Khan, that is my client, to live and reside with me at my building, 14 Dr. Ishaq Road, formerly 14 Kate Street. I treated Mohammed Abdul Khan as my own son, and the said Abdul Khan, his wife Nagmana Parveen, and Mohammed Mubashir Khan looked after all my needs and provided me with proper and necessary medical treatments. Mr. Mohammed Abdul Khan and his family for all these years since 82.
So you challenge the notification.
I am challenging the notification, yes, my lord. Now, my lord, the sine qua non under the Escheats and Forfeitures Act, my lord, is that there has to be a finding under section 2G of the Act, my lord, that there is no legal error in respect of the property. And on that finding, my lord, the proceedings are initiated. My humble submission is the initiation of the proceeding itself is especially without jurisdiction because, my lord, your lordship has seen, my lord, if your lordship will kindly turn the page in the will, my lord, running page 31, the executrix in this will is Nagmana Parveen, the mother of the petitioner.
No, the order was passed in 2018.
Yes, my lord.
Okay. And you have challenged in the 2023.
Yes, I'm explaining that, my lord. I'm explaining exactly that. Nagmana Parveen is the executrix in the will. She had filed a police case. My lord, that is case number 255 of 2015. Subsequently, my lord, she had filed another person, my lord, Mr. He also filed the PLA case seeking to intervene first in the PLA case, then seeking probate of another will, under which he claimed. This court found that he had no claimable interest. And the judge, my lord, sought to intervene for evaluating the PLA case, saying that they have an interest, I have an interloper. Trespasser filed police complaints against me, apparently several heinous allegations, I am stealing, I am trespasser, etc. So court found the Armenian church has no claimable interest. Ultimately, my lord, I was the mother of the petitioner, Nagmana Parveen, who is the executrix in the will, was compelled and constrained to withdraw her PLA case under coercion and duress because there were so many criminal complaints against her. Why we come and challenge these proceedings, my lord, now is because there's an FRT that has been obtained on 3rd September 2021 in all these criminal cases. Page 112, saying that these are civil disputes. So, my lord, this sword has been hanging on my head. Your lordship is saying I am domestic help. My resources are limited. The father of the petitioner, husband of this Nagmana Parveen, died in 2015. My lord, all these criminal cases have been initiated, pursued against me. FRT obtained in 2021. And my senior friend, I'm sure, will come and show your lordship that when this PLA case 255 was withdrawn, an affidavit was filed by Nagmana Parveen and the petitioner saying that we have no claim under the will. We will not pursue any claim under the will. My lord, that is not free consent because lordship knows.
So what is the stage of the PLA?
The PLA case, my lord, there is an. While it was being considered, my lord, this contempt application was filed and these orders are passed. Orders are annexed here in the petition. It's there. It's here. It's here. My lord, in the PLA case, your lordship will find at page 130, page 305 also, there's the same order that is placed before your lordship, 15th May 2023. 15 May, Prothomachur, matter is adjourned. It said that expected the party shall not alter the present position till the next date or until further orders. This is thereafter, my lord, continued. And my lord, status quo was granted, extended, and then ultimately, my lord, this is the order, 2nd August 2023. Kindly see at page 2, second last paragraph. Application is adjourned, sine die with liberty to mention. It is expected that the party shall not alter the present position till the next date or until further orders, which was enforced.
On what ground you are challenging this order?
My lord, I am challenging.
What are the grounds challenging this order?
Yes, my lord. The ground is this. If your lordship will see, my lord, there is a judgment that I would like to place reliance on. If I will place that, my lord, that will help me elaborate.
In the order, if you come to the page number 302.
Yes, my lord.
For the purpose of inquiry, the competent authority issued cause published in the Calcutta Gazette, and there is the newspaper. So you're not challenged that.
At that time, my lord, the criminal cases are pending against me. I have not taken any steps. I'll be very candid. Now, my lord, the Escheats and Forfeitures Act, when the scheme of the act is placed before your lordship will find that anybody who is aggrieved by these orders of vesting on these notices, my lord, they can appeal. They can make representation in response to the notice your lordship has seen, my lord, under.
That's I'm asking.
Yes, I haven't done that because, my lord, then the criminal cases are pending against me.
So,
same reason that I was compelled to withdraw the case. My lord, the scheme of the act says that.
Who is threatening you?
I beg your pardon, my lord?
Who is threatening you?
My lord, this Sunil Sobti, one person, I'll show you Lordship all the criminal complaints. The Armenian Church, my lord, specifically, 7 police complaints, my lord, against me and pursued against me. This is the threat, my lord.
After withdrawal,
Yes.
the state filed the BPK filed
My lord, only one thing, my lord. I'll show your lordship a decision of the Supreme Court, which says that when these notices are being issued, my lord, under 4.3, when an opinion is found under section 2, subsection G of the Escheats and Forfeitures Act, that there is no lawful error, then, my lord, the onus is really on the state to demonstrate that there is no error. Now, my lord, I say that this notice that is issued and this entire proceeding under the Escheat and Forfeitures Act initiated is without jurisdiction. Why? Because, my lord, the lordship has been told that withdrawn the PLA case, the member is withdrawn the PLA case, and they have also filed affidavits saying they will not make any claim under the will. It is a registered will, first of all, my lord. So there is a prima facie presumption of validity. Number 2, my lord, the state to the proceedings. It is on the state's application that these affidavits have been disclosed to the court, saying that we will not pursue the case, we will not claim under the will. So the state was already that the registered will under which I am claiming. I am the beneficiary under this will.
No, so when you disclose the will,
No, the PLA case has been filed in
when which year?
2015. No. The originally PLA case was filed 2/25 of 2015. State has been filed to that.
Correct.
State has filed the application number to the court saying that I am withdrawing. When Praveen is withdrawing, she will not proceed. The petitioner here, Mubashir Khan, will also not claim under the will. So the state was party to the proceedings and aware.
No.
Of not claim to the right to.
Who has withdrawn the PLA?
He has filed the executrix. Petitioner's member.
Correct.
My lord, may I just show your lordship? There's this application filed by the state. Directly, may I bring your lordship to that? If the withdrawal is brought on record by the application of the state. My lord, kindly see page 48. This is the state's application. Volume 1, page 48. Kindly see, my lord, this is GA number 3250 and in PLA case number 225 of 2015. This is filed by my mother. Now, kindly see, my lord. Next page, my lord. Humble petition on behalf of the state of West Bengal. So this is the petition of the state.
Which year? 2017.
2017. So, my lord, the state says paragraph 8, if my lord will have at page 52. Or my lord, kindly come to paragraph 12 at page 53. During the pendency of the proceedings in this honorable court, the said Nagmana Praveen has categorically stated that she did not want to proceed with the testamentary proceeding PLA number 225 of 2015 in the goods of Annette Mary Emily Apkar. Copy of the affidavit executed by Nagmana Praveen is annexed here to and marked with the letter B. Thereafter, my lord, also. So, my lord, it is on the basis of this. Kindly see the prayers at page 55. Prayer B asks for dismissal of the PLA case. So the state has been party to this proceeding. State knows that I am claiming under registered will. The case has been filed. State brings on record the affidavit of the executrix, my lord, saying that she will not proceed. And there is also an affidavit filed by the petitioner, my lord. I'm making a clean disclosure, my lord. I don't want to. There is no hide and seek at all. That is, my lord, at page 58. Now, 72, my lord. 10th July. 2017 affidavit of the petitioner also saying that he will not raise any claim under the will. Oh, the petitioner before your lordship today, my lord, Mubashir Khan, son of Nagmana Praveen, who had filed the case 255. So, filed an affidavit that is at page 72, my lord, July 2017.
This is also state has disclosed.
Yes. This also state has disclosed in the application. At page 73, my lord, he has said, I will not make any claim under the will. So, my lord,
and shall never claim the
Yes.
right at an interest of the property of the deceased at any time.
my lord, my humble submission is this. Estoppel, my lord, is willful relinquishment of a known right. This is not a willful relinquishment because they were operating under duress, my lord, and coercion. My lord, reserved to or my lord, exercised upon them by the various police.
Contested the notice of the 2018 of the administration issued to the.
My lord, for the same reason that I was constrained to withdraw the PLA case. See the police complaints now, my lord.
Correct.
Page
So
41
how
on.
at this stage the court can look into that?
The statute says that the court can, even if I have not made a representation in response to the notice, even if I have not approved the order, after that, appropriate authority, my lord, under the Receipts and Forfeitures Act, my lord, writ petition is maintainable to challenge. So, my lord, at that juncture, my lord, I really could not exercise my rights because of the duress and coercion that was, my lord, being exercised upon me. These complaints filed by the other person claiming, my lord, interest only in church, my lord, where these allegations were made against me. But when the FIR is issued, my lord, against me, yes, the 3rd September 2021, kindly see at page 112, my lord, when that FIT is gone, that sword that was hanging over my head goes. And my lord, I immediately proceeded to file an application granting letters of administration. There's a residual legality in the proceeding under the will, and I will also challenge the listing.
Page 106. Page 106.
Yes. Yes, madam. What is the stand?
May I just say one more thing, my lord? There's a Supreme Court decision which categorically says that the state has to show that there is no error. My lord, the state was party to the PLA case that I have shown your lordship. They filed the affidavit saying that I will withdraw. So they were aware that I am claiming under registered will. Registered will has a presumption of validity. There is a will. I am claiming
The effect of withdrawal of the earlier PL.
withdrawal ordinarily would mean I'm giving up my right, my lord. But I'm telling your lordship, my humble submission is the withdrawal is not free consent. That is something your lordship will have to consider. Withdrawal is not free consent. Withdrawal is because I was being acted upon on the basis of my lord, or really my lord, caution or duress was being exercised against me on the basis of these complaints.
Which year?
Kindly see, my lord, complaints are right from page 43 onwards, 41 onwards. 30th June 2016 is the first police complaint. 29 June 2016 is the second complaint, page 42.
Why so much the case has been initiated? Why?
Because, my lord, I am a servant claiming an interest in the property. So naturally, my lord, everybody, and we know naturally is the person who detested and issueless. So it has become a free for all. One church comes and claims an interest, one developer comes and claims an interest, one watchman comes and claims an interest. And I am a person of legal means. I am domestic help. So I have to count out and I don't have the means to fight.
If that's so if the state, okay, you are not, if the state has issued a notice under the West Bengal Estate Act, so why the other person has not come? If your case is taken into consideration.
Yes, my lord. The other persons during the pendency of my case have already withdrawn. Armenian Church proceeding to the caveat. The Honorable High Court has held that they have no caveatable interest. I will show your lordship that order. Kindly see, my lord. Page 45. July 2017 order of the High Court discharging the caveat of the Armenian Church holding they have no interest. There is another gentleman, who also, my lord, filing an independent penal case seeking to claim under a different rule. Court also has no right. Withdraw the case. So the member has any claim other than me.
Okay.
The jurisdictional fact, the state has to enter into finding that there is no one with any interest. You actually seeing the notices that are being entered here. There is no discussion. The PLA case was filed, the registered will.
Present this PLA which is pending.
Yes, ma'am.
Which year that PLA was?
2021, my lord.
22.
21. 3rd September 2021, I got the FRT, my lord, and the present PLA case.
4 January 2022.
4th January 2022, my learned senior friend tells me, my lord. It is 438 of 2021. PLA 438 of 2021, it is filed.
Yes.
I have shown your lordship the order of 2nd August 2023 in that, my lord. So, my lord, my humble submission, if I may show your lordship that judgment for completeness, my lord, Supreme Court says that, and the instruction was a withdrawal. So, it is very relevant. May I just place that judgment, my lord. 2021 16 SCC 400. Too much judgment. Can you allow me one moment?
Okay.
2021 16 SCC. Yes, my lord, I found a copy. I beg your pardon, my lord. Ma'am, citation दिए दीजिए 2021 16 SCC 2021 volume 16 SCC page 400. I'll just give you a copy, ma'am.
Page 40?
400. My lord will kindly have from paragraph 96, my lord. That is at page 51 of the report.
Paragraph
96.
Yes.
My lord, if I may just place it, the proposition that escheat is a doctrine that recognizes state as paramount sovereign is a clear case of failure of affairs. In that, when a claim of escheat is put forward by the government, the onus lies heavily on the government to prove the absence of any error anywhere in the world. Find support from the judgment of this court in Kuchilal Rameshwar Ashram, Eva Manna Kshetra Trust versus Collector. Referred to by my esteemed sister. As noted by my esteemed sister, the single bench of the Delhi High Court had dismissed testamentary case number such and such, holding that the executors of the will had not been able to prove the will and codicil. And my lord will kindly take is paragraph 102. This is relevant. The fact that I just give your lordship the factual background, my lord. Here, a trust was claiming, my lord, it's on the estate, my lord, had it, which they subsequently withdrew. The trust failed in probate. At that juncture, my lord, the earlier withdrawn the probate, they now came to the property. So the question was, when they withdrawn here, they came to the property and cheat. Investing in the state. That is the actual background in which this decision is passed. Kindly see my paragraph 100. It is true that the respondent trustees filed the writ petition basing their claim on the will. The locus standi of the writ petitioner was never an issue. By entertaining the writ petition, the High Court, in effect, accepted the respondents, trustees of the trust had locus standi to file the petition, and rightly so. The writ petition filed by the trustees, having been entertained and keeping pending, the High Court would not have been justified in dismissing it on the ground that the trustees have no right to claim in the properties in question in view of dismissal of the probate case. More so when the appeal filed by the trustees is still pending. The High Court was right in not dismissing the writ petition. The fact that the High Court had earlier on the prayer of the trustees adjourned the writ petition sine die to await the decision in the application did not debar the High Court from exercising its writ jurisdiction after disposal of the probate case. At the cost of repetition, it is reiterated that even though the probate case has gone against the trustees, the appeal was and is still pending before the division bench, as noted by my esteemed sister. My lord is also similarly, my lord, directed the state to take instruction that while the probate case is pending, my lord, this proceeding can be in abeyance, exactly as has been held here. In paragraph 105, my lord will kindly have. As held by this court in the state of Bihar versus Krishna Singh, the onus to establish that a property is bona vacantia is on the government. The burden of proof is heavy. The proposition also finds support in the judgment Kuchilal Rameshwar Ashram Trust.
In the PLA, the state is not appearing.
I beg your pardon, madam?
In your PLA, state is appearing.
It is on the state's application that those affidavits were the
No, PLA.
No.
they are appearing, they are contesting. They have been given notice. No. They have filed affidavit, madam. They have filed caveat in the present PLA, and their content order has also been valid.
It is why it is not continued?
My lord, the honorable court was of the opinion that if the property that we are fighting over is vested in the state, and that question cannot be adjudicated into the case. So I would challenge it separately, which is what I can make this petition.
That's correct. But why? Only court has to see the will is genuine or not.
Your lordship is absolutely correct, my lord. The court will see whether I have an interest, but the property, my lord, the golden fighting of the state, and the validity of escheat and forfeiture cannot be determined by the PLA court. That is the opinion. No. But the states and the property have already gone. It's vested in them, that is not challenge, and I'm fighting for administration of the estate. That is the question.
No,
which one will be disposed first, or the vesting will be challenged first?
My contention is, my thinking is that if you will get the probate,
yes, my lord,
it is under challenge. Then you can go for the title.
If I am simultaneously also.
Even though,
so I can
if you get the probate, that is one of the extra evidence you will get.
That is quite correct, my lord. And also under the Escheats and Forfeitures Act, it says that, my lord, to contest the proceeding, I have to demonstrate that I have an interest to maintain application for letters of administration. That is what, my lord,
the writ petition. That's why see in the writ petition what the court will do.
My lord, whether the vesting is valid or not, lordship.
That is only.
Yes, only that.
That is only the court. Then it will affect all the proceedings.
It will affect all the proceedings, my lord. And
the proceedings. If suppose the court will held the order is valid.
Yes. So, my lord,
that I am thinking on that.
But that is why the court has kept this subject to the adjudication of the writ petition. Because, my lord, what we're fighting.
Vice versa.
Issue is this, my lord, that if I just, my lord, finish placing this decision, my lord, I was seeking to, my lord, place 118, my lord. I think I had placed till
106.
Is that paragraph 104, perhaps, my lord? Well, can we see? Yes, 104. Show, my lord, that the onus is on the state. Then, my lord, will kindly have one. Yes.
Naturally, the onus will be on the state because state has to prove with regard to them there is no claim.
Yes.
No claimant has come forward lying vacant and the government has like a resume.
Lordship.
Has like a resumption.
One or two paragraphs more, my lord, if I may invite your lordship's kind attention. If my lord will kindly see paragraph 118 at page 57 of the report. We see, my lord, 118. The cabineters who objected to grant of may very well advise not to proceed in view of the weakness of their case, or maybe for other reasons. That would not make any difference to the state status as agnates or cognates of the deceased testator. Then, my lord, 122 at the next page. The condition precedent for initiation of proceedings under Escheat Act is failure of heirs. In the absence of any finding of failure of heirs, proceedings could not have been initiated. Under Section 4, it is the duty of the tehsil to see there is no one entitled to the property. The purpose of taking property or disturbance of possession thereof if the property is in possession of anyone. And 125, my lord. Significantly, in this case, the proceedings under the Escheat Act were initiated and other orders, communications implemented, the petition was issued without any finding of complete failure of heirs. In the absence of formation of opinion of failure of heirs, the proceedings initiated under the Escheat Act were wholly without jurisdiction. So essentially says the same thing, not alternative remedy, not because of proceedings without jurisdiction, there's no finding. There is no heirs. The state is in the no. Registered will done. No mention of the simply just say one line, no heirs. And they contested the previously 2021 PLA, they also considered contesting. Right up to page 138, paragraph 130, the Honorable Supreme Court says the alternative remedy will therefore not be when the proceedings initiated without jurisdiction. This is my humble submission.
And that's correct. No, I am thinking on other way.
I appreciate what is coming from my lord. My lord, cases there are not. If I can show that, my lord, I have an interest sufficient to maintain an application for administration, which I can do on the basis of a registered will, my lord, registered document. No one is called for delivery and cancellation of the document. In these circumstances, my lord, whether I have the locus to challenge the proceeding. And my lord, I should have seen the notices. They don't even mention these antecedent facts.
So that's I'm telling. That's I'm telling is the 2013 and these are 2018.
Yes, my lord.
And subsequent also they are participating.
They are participating and they have not made a whisper of any of this. So it's without jurisdiction.
There is a case also pending. So let me hear the statement. Yes, madam.
Yes.
Right.
My lord, first of all, kindly take.
Come on, next.
Next.
My lord wanted, my lord.
My lord, we fixed it on the other day. Kindly fix.
Petitioner has argued the matter at length. Has concluded his argument, full stop. Due to paucity of time, the respondent could not argue the matter. According case adjourned, let the matter appear. Let the matter remain in the list.
My lord wanted,
Remain
my
in
lord.
the list. Lordship. Yes.
My lord,
Yes.
it was the consent order, my lord.
What consent order?
But the property, my lord, position was taken by the Public Premises Act. When, my lord, I'm so sorry, but I'm
Tomorrow, yeah. Can it be Monday? The marriage. Any day, Lord.
11th.
Very good.
all on a sudden, my lord, the position was taken. Every my belongings.
Who are you?
My lord, I am, my lord, the original tenant, my lord. Every my belongings, I am an octogenarian lady. Every of my belongings remained inside, including my medical.
What you want?
But only when they are also willing, my lord, they will make it open, my lord. We will get our goods and all other issues. Item 6. All other goods, my lord, everything is there, my lord.
they will keep it open, my lord, we will get.
When the possession was taken?
My lord, the possession was May 22nd, 2026.
Where is the order?
But the
Where is the state officer order?
My lord, kindly come to my lord. But kindly come to page 103, my lord, warrant of possession, my lord, by which, my lord, the warrant of possession.
Where is the state officer order?
And the state officer.
Page 24.
Page 24, my lord, it is. And my lord, may I hand up just the photograph, my lord, of the.
Photograph what will do?
My lord, it is our padlock on which, my lord, with the clothing that, my lord, they have sealed it and taken the position. That is the procedure under the Public Premises Act.
Correct. That's where. What is the date of the order of the state officer? 28 February 2023. 2003.
2003, my lord. Thereafter the procedure, yes. That but the original order. Against that, my lord, we have filed the appeal before the City Civil Court.
Against you?
Against yes, my predecessor, my lord. And my lord, the City Court immediately stayed the officer of the order of the estate officer.
City Court, civil suit, and
no, my lord. No, my lord.
Appellate authority.
Appellate authority. City Court is the appellate authority. Yes,
district judge.
District judge, my lord. Of the
Then where is the district judge order? Where is the appellate court order?
My lord, the appellate court order কোথায় আছে দেখো? That is everything is there, my lord.
City Civil Court at Calcutta.
Yes, my lord.
Restoration of miscase. Where is the order of the district judge?
Page 48 onwards, my lord.
Where is the order of the district judge?
Yes, my lord. That is, my lord, page 48, my lord. P2.
48.
Yes, my lord. Yes, my lord.
48 the state officer.
No, my lord. Page 48, P2, my lord.
Where is the order? Where is the impugn order? Where is the final order?
Page 48. Yes. But kindly come to my lord. The appeal is taken up for hearing on admission.
Then thereafter what is that?
And my lord, thereafter, my lord, the proceedings went on. In the meantime, the original tenant died, my lord. We failed to substitute.
When the order was, the district court has disposed of the appeal.
Yes, my lord.
When the district court has disposed of the
appeal, my lord, appeal is not disposed of. But may I say, my lord, appeal stood abated, my lord, without timely
appeal is dismissed.
No, my lord, it was abated, my lord.
Abated.
And thereafter, by virtue of the order of the Honorable Court, we had got the leave to file the application before the City Civil Court for the cancellation of the abatement. That is filed, my lord. In the meantime, my lord, the proceeding was dismissed for default, and there was, my lord, in the meantime, they had taken this position by way of warrant of possession.
Where is the warrant of possession?
My warrant of possession 103. Warrant of possession, that was not served upon them initially.
You will not proceed with the matter before the.
Yes, it is already proceeding.
You will not proceed further.
Yes, we are proceeding. When the next date,
so you are accepting the.
No, my lord. But kindly see, we have already, my lord. In the meantime, my lord, they have taken the possession of the entire property. Correct. But inside that there are my belongings. Only that belongings that I am entitled to. They are also willing, my lord, that there are no objection if I get out of my all belongings. The status. The last page is the order. They will file written objection. Everything is. Kindly see, my lord. Next is on August 24. In the meantime, they have taken this position. That's why I have come only for this. Let the position remain with them. That would be adjudicated by City Court. But in the meantime, my belongings should be released. Only that part. Only that part, my lord.
So what is your prayer? That only?
That only, and obviously, as both consent of the parties, my lord, both parties will abide by the order of the. In the meantime, if any coercive steps they need to be taken, they will approach the City Court and nothing else. Even either party will approach the City Court. And nothing else.
The petitioner has filed the present date application.
What is the procedure?
Praying for direction upon the respondent authorities. Respondent authorities to permit the petitioner
to open the padlock.
To open the padlock and to remove her all belongings.
My lord.
That is movable articles. All belongings from the premises. Where is the schedule?
Flat number 3, second floor, Metropolitan Building, 7 Jawaharlal Nehru Road.
Situated on the second floor of Metropolitan Building, 7, JL Nehru Road, Kolkata 13.
7 lakh 30.
Under TC file number 1013 within the Municipal Corporation of Kolkata. The predecessors of the petitioners again the respondent authorities have initiated the case insurance company has initiated
LIC,
the Life Insurance Corporation of India initiated a state case against the petitioner against the predecessors of the petitioner who was the original tenant of the premises in question for eviction. The state officer has passed an order order of eviction against the predecessor of the petitioner who was the original tenant. Being agreed and dissatisfied with the order of the state officer, the predecessor who has filed the appeal, predecessor of the petitioners have filed an appeal before the London District Judge under the Public Premises Act.
In March 2020,
the said appeal was abated due to the death of the predecessors of the petitioner. Subsequently, the petitioner has filed an application before this filed a revisional application, and in terms of the order passed by the court bench of this court in the civil revisional application, the petitioner has filed an application before the London District Judge for restoration of the appeal filed by the petitioner, and the same is pending for adjudication. During the pendency of the said application, the respondent authorities have taken the taken possession, have logged.
No, my lord, the warrant of possession they have issued by virtue of that my padlock, thereupon they have sealed that.
Have issued the warrant of possession and have sealed the premises over and above the padlock of the petitioner the premises.
That is I want to say one thing. A miss case has been filed by the petitioners before the London City Civil Court, and that miss case was dismissed for the court.
What do you mean?